Ashur Singh, Srimati Ajanta Ne,
on the rights of the child were adopted by the United Nations in 1989, offences against children were not specifically redressed by way of any special legislation in India till the year 2012. The POCSO Act has been instrumental in providing a robust justice mechanism for victims of sexual abuse and has highlighted the significance of child rights and their safety. The need of hour is to sensitize the public regarding child abuse in all forms so that every crime gets reported. It is also important that the stakeholders in the implementation process of the Act are made aware of all the provisions of the Act. The Government of Assam has provided funds for creation of child-friendly environment in the POCSO courts. I am hopeful that this consultation will lead us in the right path to fight crime against children. Before concluding, I would like to thank the Juvenile Justice Committee of the Honorable Gauhati High Court for having mooted this idea of having a multi-state level consultation on implementation of the POCSO Act. With these words, I once again welcome you all and offer my best wishes for the successful completion of the state consultation. Thank you.
Thank you so much, sir.
Next, we have an address by Dr. Malulika Jonathan, Chief, UNICEF Office for Assam and the Northeastern States.
Good morning, everyone. Dignitaries on the dais, Honorable Mr. Justice and Pradesh Singh, Chairperson, Juvenile Justice Committee, Gauhati High Court, Honorable Judges of the Gauhati High Court, Srimati Ajantaniya, Honorable Minister, Women and Child Development and Finance, Govt of Assam, Shri Alu Libang, Honorable Minister, WCD, Government of Arunachal Pradesh, Shri Mukesh Chandra Sahu, Principal Secretary, Women and Child Development Department, Government of Assam, Shri Tapadar, Secretary, Juvenile Justice Committee, Honorable Gauhati High Court, esteemed dignitaries representing the state governments of Arunachal Pradesh, Nagaland, Mizoram and Assam, Chairperson SCPCR, Assam and Mizoram, officials from government and judiciary, members of civil society, organizations, eminent panelists, and colleagues from UNICEF. It is a privilege to be here today, and on behalf of UNICEF and the organizing committee, I welcome you to the second day of the 4-stage consultation on the implementation of the POCSO Act of 2012. Violence against children has lifelong ramifications. Exposure to violence at an early age inputs cognitive development, leading to educational and vocational underachievement. Such children are more likely to drop out of school and have difficulty in retaining and even finding jobs. The direct cost of violence includes the cost to health, to social welfare department, and the criminal justice system. The indirect cost pertains to the impact of physical, sexual, and emotional violence on children across their lifespan, which can lead to decreased productivity and increased burden on the health system and disruptions to social cohesion. The protection of children from sexual offenses, the POCSO Act of 2012, aims to provide justice and rehabilitation to children who have been sexually abused, largely through its stringent provisions. And this Act of 2012 now necessitates a comprehensive review of its implementation, and with the increasing number of POCSO cases across the states, it is important to identify the gaps which need to be addressed. Few areas that I would like to bring to your attention are: in 2021, as per the National Crime Review Bureau, the high pendency of POCSO cases, especially those exceeding 1 year mark with the judiciary and 2-month mark with police, is an area that we can work on together in a coordinated way to ensure that children receive timely redressal. As per the NCRB, since 2017, the pending cases for investigation have increased by 44% in 2019, with an average annual increase of 15%. At this rate, the number of pending cases will double every 7 years, and child survivors will await justice longer. This consultation is then, as Mr. Mukesh Sahu said, being organized at a very critical juncture. And this is a very opportune time, largely because it echoes the clarion call of the Juvenile Justice Committee of the Honorable Supreme Court of India, who have urged for expeditious disposal of cases with the support of all stakeholders. The second point I want to bring to your attention is the streamlining of monitoring mechanisms, which should be prioritized. Effective implementation of POCSO necessitates shifts, and these shifts are structural shifts as well as shifts in the capacity of the workforce. A shift in mindset. A shift in mindset from a mindset of scarcity to a mindset of abundance. We must create a shared accountability for monitoring progress across duty bearers, the child protection system, the police, the judiciary, medical practitioners, and the prosecution. And finally, above all, we must emphasize on prevention of sexual violence against children. Safety nets to prevent violence against children are hence key to ensure that a protective environment is available to children so that each child survives and thrives. Efforts to address violence against children are at the core of UNICEF India's programming. The focus is on accelerating actions to prevent violence and to strengthen the support to children who are survivors of violence and abuse. And with an aim to develop a strategy to end violence against children, UNICEF has supported partners to analyze secondary data on violence against children, and this data is culled from e-court judgments, National Crime Record Bureau, the National Family Health Survey, the disposal of victim compensation, and this analysis brings forth to us the bottlenecks in the implementation of special laws to curb violence against children. Some very specific initiatives from Assam, which were discussed also yesterday. The first is the Assam Police Shishu Mitra program, which is led by the Assam Police. The child-friendly Gram Panchayat constituency plan with elected representatives. The Suraksha campaign, which is with the State Commission, with the Assam State Commission for Protection of Child Rights, and area-specific interventions in the Bodoland territorial region and in the tea gardens to address the equity issues and bridge regional disparities with focus on leaving no one behind. It is noteworthy that today's sessions focus on our state's initiatives, good practices, challenges, and validated evidence to streamline POCSO implementation. And these inputs today will enable us all to work coherently with each other in the best interest of children and strengthen linkages between departments to ensure the continuum of care for children. As UNICEF, we call upon representatives who have high engagement with the POCSO system and with children at large to collectively deliberate on effective measures to speeden up the redressal of POCSO cases. I congratulate the Juvenile Justice Committee of the Honorable Gauhati High Court, the Department of Women and Child Development, Govt of Assam, and delegates from all 4 participating states for their meaningful participation. And I conclude with the assurance ensuring a violence-free childhood, which is so critical to each child and to us at UNICEF and within the government. And as UNICEF, we will stand strong with each duty bearer in this regard. Mahatma Gandhi once said, "The true measure of any society can be found in how it treats its most vulnerable members." And may our measure be found in measuring childhoods which are free of violence, untouched by abuse for every child. I thank each one of you for your commitment and participation.
Thank you so much, ma'am.
Now I request Sri Alolibam, Honorable Minister, Women and Child Development, Government of Arunachal Pradesh, to present his address.
सभी को नमस्कार। Honorable Justice N.K. Singh, Chairperson JJ, and Honorable Minister Niyokti, Madam from Women and Child Development in Assam, or जितना भी आज की present Honorable Justice from Gauhati High Court, and all the honorable members, esteemed members who also have come over here from different states of the Northeast, Assam, Nagaland, Mizoram, and Arunachal Pradesh. Really, आज हम यहाँ बहुत अच्छा काज के लिए गैदरिंग हो रहा है for the futures of children of generating children. तो इसमें ये 2012 का 32 से 2012 उसका जो पॉक्सो एक्ट का मुताबिक हमारा नॉर्थ ईस्ट में बल्कि नहीं सारा इंडिया में अभी बहुत सा लोगों को बेनिफिट मिल रहा है, बहुत सा चिल्ड्रन को हम रेस्क्यू भी कर रहे हैं और हम प्रोटेक्ट भी कर रहे हैं। तो ये बहुत अच्छा एक्ट था। उससे पहले जब हमारा अरुणाचल प्रदेश स्पेशली अभी यंग स्टेट है, तो इसमें हम लोग जितना भी आपका पॉक्सो एक्ट का ऊपर में हम स्टेट का भी हम एक 2018 में हम लोग ने एक पास किया है, जैसे उसका सपोर्टिंग में। तो अभी अरुणाचल प्रदेश में एक्चुअली हम पॉक्सो एक्ट के लिए वोमेन्स के लिए और चिल्ड्रन के लिए ये सिर्फ नॉट ओनली द फीमेल चाइल्ड, मेल चाइल्ड के लिए बहुत प्रॉब्लम हो रहा है इस दुनिया में। तो इसी के लिए हम लोग काम कर रहे हैं। तो हमारा स्टेट में अभी तक हम लोग we have 26 districts in the state, but we could have appoint only 9 judges, 9 prosecutors for this POCSO Act. और उनका ऊपर में we have only 8 special court just for prosecution because of the bottleneck of the geographical region also, or because of the shortage of the manpower also. इसी के लिए हमारे वहाँ में अभी तक चल रहा है, फिर भी सारा डिस्ट्रिक्ट में we cannot do it now. तो उसके लिए भी way forward में हम लोग कोशिश कर रहे हैं, गवर्नमेंट ऑफ अरुणाचल also trying हम और ज़्यादा से ज़्यादा मैन पावर उसी में इम्पोर्ट करें। तो उसमें हम लोग 26 डिस्ट्रिक्ट में कवर करने के लिए मैन पावर चाहिए, और 26 डिस्ट्रिक्ट में ये हमारा प्रोसिक्यूशन जो जांच करने के लिए और आदमी चाहिए, वो अभी शॉर्टेज है। तो उसके ऊपर में हम लोग गवर्नमेंट ऑफ अरुणाचल प्रदेश चिंता कर रहे हैं। लेकिन जो वेलफेयर, जो चिल्ड्रन वेलफेयर कमिटीज और जुवेनाइल जस्टिस बोर्ड हम लोग ऑल डिस्ट्रिक्ट में अभी लागू किया गया है। और इसका ऊपर में हम लोग ये में जो पुलिस ऑफिस में जो वुमेन पुलिस स्टेशन भी हमारे वहाँ में कम किया है। वी हैव ओनली टिल नाउ वी हैव ओनली 7 पुलिस स्टेशन देयर इन होल स्टेट ऑफ अरुणाचल प्रदेश। तो वही भी मैन पावर्स का कारण से है। तो जितना भी हम लोग उसमें वुमेन पुलिस है, उसमें वन स्टॉप सेंटर में भी हम लोग बहुत कुछ ये काम कर रहे हैं, वन स्टॉप सेंटर में भी। और जहाँ में हम लोग कर रहे हैं वहाँ मेन अवेयरनेस का जरूरी है। तो अरुणाचल प्रदेश में अरुणाचल लीगल अथॉरिटी और उसमें ये जेजेम का, और हम लोग ये अवेयरनेस CBOs को भी ले लेता है, विलेजर्स को भी ले लेता है, पंचायत मेंबर्स को भी ले लेता है, और डिस्ट्रिक्ट लेवल से ब्लॉक लेवल तक, विलेज लेवल तक हम कोशिश कर रहे हैं जो ये के लिए जस्टिस ये के लिए। तो अभी इससे पहले हमारा वहाँ में इतना रिपोर्ट भी नहीं था। अभी ये अवेयरनेस होने का कारण से बहुत सारे लोग को जो उनका विक्टिम्स है, दे आर रिपोर्टिंग टू द कोर्ट ऑल्सो। तो जस्ट रिसेंटली 24 जिस मंथ उसको वही में एक ये वहाँ हमारा बोमडिला में एक तो ये प्रिजन भी दे दिया, सेंटेंस किया है, जो असम का तेजपुर का रेसिडेंट था, वो इन्वॉल्वमेंट किया था सेपा में एक माइनर का रेपिंग में। तो उसको भी जस्ट रिसेंट लेके ये किया है, वो मार्च में था, जो एक्सपेक्ट किया है उसको। तो अरुणाचल प्रदेश में हम लोग का अभी जो इस ये को एक्चुअली लोग अभी नहीं समझता है। तो इसी के लिए हम मास एक अवेयरनेस का बहुत जरूरी है। और उसका ऊपर में लोग नहीं समझता है, इवन दे आर रिलैक्टेंट टू रिपोर्टिंग। उसको मतलब रिपोर्ट करने के लिए अपने माँ बाप को बताने के लिए भी बहुत जरूरी है। तो इसी के लिए अवेयरनेस का मस्ट जरूरी है। अवेयरनेस सिर्फ नॉट इज चाइल्ड, अवेयरनेस ये जो एजेड वाला लोग को भी हम लोग अवेयरनेस देना चाहिए, क्योंकि एजेड वाला लोग ही ये एक्टिविटीज़ कर रहे हैं। क्योंकि इसमें जो अवेयरनेस कर ये एक्टिविटीज़ करने वाला मैक्सिमम टू एसेंट्रिक या उसका माइंड में कुछ ये वाला हेल्थी नहीं वाला लोग ही कर रहा है। तो इसलिए हम जितना पॉपुलेशन है, सिटीजन है, उसको हम अवेयरनेस का बहुत ज़रूरी है। मेन तो इसका अवेयरनेस है और उसका शॉर्ट फिल्म भी हम लोग और मीडिया में भी देना चाहिए, इसमें क्या रिपोर्टेशन होता है। ऐसा होने से लोग समझेगा, नहीं तो आप विक्टिम्स होके भी वो रिलैक्टेंट होता है अपना माँ बाप को बताने के लिए, और माँ बाप भी वहाँ में फिर और कोर्ट में बताने के लिए फिर राजी नहीं होता है। तो उसको हम सही जानकारी देना पड़ेगा, ठीक से काउंसिलर हम करना पड़ेगा। तो इसलिए हम लोग काउंसिलर ठीक से काम करना है, एंड काउंसिलर अवेलेबल हम लोग होना चाहिए। और उसको ये करने के लिए जितना भी NGOs है, CBOs है, जितना भी स्टूडेंट ऑर्गेनाइजेशन है, वो सबको भी हम इन्वॉल्वमेंट करना पड़ेगा जितना से ये है। अदरवाइज इसको हम लोग आगे ले जाने के लिए तकलीफ है। मैं अपना कास्ट करके अरुणाचल प्रदेश का ये कॉन्टेक्स्ट में बता रहा है ये। तो हम अभी कर रहे हैं जितना 26 डिस्ट्रिक्ट है उसमें हम लोग जो स्पेशल कोर्ट हम लोग बैठाना चाहिए, और उसके ऊपर जो इंडिपेंडेंट कोर्ट होने से ठीक है वो हम लोग सोच रहे हैं। नहीं तो स्पेशल कोर्ट में भी वो लोग ये हो जाता है, उसमें इंडिपेंडेंट जो फुल प्लेजेंट कोर्ट होने से ठीक है एवरी डिस्ट्रिक्ट में, और विथ मैन पावर। और उसका ऊपर में हम ये जितना भी जुवेनाइल ये है उसको हम लोग ये एक्सपेक्ट करने के लिए ये जितना भी ये स्कूल है, इंस्टीट्यूशन है, वहाँ भी हम लोग इवन मॉर्निंग टॉक में भी बताना चाहिए। मॉर्निंग टॉक में जब ये हो जाता है उसमें सब कुछ बताना चाहिए। इवन एनी अदर बड़ा गैदरिंग होगा, ये एनी गैदरिंग उसका वहाँ में भी एक सब्जेक्ट बताने से ठीक है, क्योंकि उसमें एबेल करके एक सब्जेक्ट बताने से ठीक है। एवरी मीटिंग्स में भी, फेस्टिवल का ओकेजन हो, एनी अदर फंक्शन हो, उसमें भी हम लोग ये बताने से ठीक है। सिर्फ ये सब्जेक्ट हम लोग यहाँ में नॉर्थ स्टेट लेवल में हम लोग यहाँ अभी एक्सपोज मतलब गैदरिंग हो रहा है, इसको हम लोग डिस्ट्रिक्ट लेवल में, ग्राउंड लेवल में और ये ब्लॉक लेवल में, ग्राउंड लेवल में ले जाने से और ज़्यादा हो जाएगा। तो इसलिए मैं असम का प्रेजेंटेशन का भी बताया अभी ने, रियली जो अच्छा काम करे उसको हम अपना स्टेट में रेप्लिकेट भी कर सकते हैं, और अदर स्टेट में जहाँ अच्छा काम करे उसको दूसरा स्टेट में भी हम लोग काम कर रहे हैं। ये रियली वेलकम स्टेप है हम लोग जो ऐसा हम लोग प्रोग्राम ले रहे हैं। तो हमारा वहाँ में हम लोग सिर्फ वे फॉरवर्ड करने के लिए अभी हम लोग काम कर रहे हैं, उसको मतलब सपोर्ट गवर्नमेंट भी दे रहे हैं, हमारा गवर्नमेंट भी दे रहा है, और उसमें फाइनेंशियल जो इन्वॉल्वमेंट है उसका गवर्नमेंट ने हम लोग को एयरमार्क किया है, हम लोग का फाइनेंस में भी। तो आज रियली जितना भी अदर स्टेट से है बहुत बहुत धन्यवाद। आपका प्रेजेंटेशन को भी हम लोग देख लेगा, और अरुणाचल प्रदेश में अभी ये शुरुआत कर रहे हैं और काम भी ये हम लोग का जो अचीवमेंट भी हो रहा है, क्योंकि ये पास होने के बाद में विद इन 10 ईयर्स में 12 से 22 में उसका ज़्यादा रिपोर्टिंग भी ज़्यादा हो गया, और हम लोग जो जितना जस्टिस देने वो सब भी हम लोग दे रहे हैं। इसके थैंक यू वेरी मच।
Thank you so much, sir.
We now have an address by Srimati Ajanta Neo, Honorable Minister, Women and Child Development and Finance, Govt of Assam.
The problem is that people are reluctant to do it. I know this is a challenge. This is a basic challenge also. The reporting itself is because it happens in family surrounding, familiar surrounding.
Honorable Mr.
They are
Justice
hiding it.
N.K. Singh, Chairperson, Juvenile Justice Committee, Gauhati High Court. Honorable Judges present here, my esteemed colleague from Arunachal Pradesh, Mukesh Sahu, Principal Secretary, Govt of Assam, Dr. Jonathan, Chief UNICEF Office for Assam and Northeastern States, judicial officers, delegates from Assam and neighboring states, representatives for academic institutions, civil society organizations, distinguished guests present here, ladies and gentlemen. At the very outset, I would like to congratulate the honorable members of Juvenile Justice Committee, UNICEF officials, and team members from my own department for organizing this consultation under the aegis of the Gauhati High Court. The aim of this consultation is to develop a strategy to address violence against children, particularly with reference to child sexual abuse, and contribute to enhance the quality of law implementation, particularly the provisions of POCSO Act 2012. Let me reiterate, all children have the right to be protected from violence, exploitation, and abuse. But still, they suffer from violence, exploitation, and abuse day by day. This is reflected in the recently published NCR report 2021. The Protection of Children from Sexual Offences Act 2012 is a gender-neutral legislation that aims at protecting children from all types of sexual abuse. It was enacted in the year 2012 to bring into force a robust legal framework for the protection of children from sexual offences, define child-friendly procedures to avoid stigmatization, and seeks to provide speedy trial of offences through special courts. The idea behind this progressive legislation was to create a separate structure and system within the existing framework of the judicial setup to provide special assistance to children who are victims of sexual abuse. One of the cornerstones of the POCSO Act is its mechanism to provide speedy justice to children who are victims of sexual assault. As per the National Crime Record Bureau, the reported crimes against children are on an increasing trend. So, on the one hand, increase in reporting of violence is encouraging. On the other hand, the significantly high number of cases of children aged about 16 to 18 years in elopement cases, there is an urgent need to facilitate discussions on the issue of the age of sexual consent. The distinguished gathering in the consultation should also examine the impact of POCSO Act on children and gender. POCSO was enacted for preventing sexual violence against children of any age and gender. In view of the available evidence, this would be the right time to examine the age profile and gender of the accused too. So, Government of Assam has taken a number of proactive steps in this regard. So, we have organized numbers of training and orientation programs have been conducted for child protection functionaries, including police, JJB, support persons, POCSO court judges. So, my humble suggestion before this August gathering is that prevention and monitoring mechanism need to be set up to work towards transforming societal attitude and building a protective environment for children by making the community level child protection committees more functional. Secondly, investment would be required in enhancing the investigation skills of the police and their sensitization was also building the capacity of special courts and special public prosecutors to innovate and move away from the conventional methods of functioning to meet the objectives of special legislation like the POCSO Act. Thirdly, the curriculum of school, police, and judicial academies should be developed, including initiation and refresher training programs, and should be contained a module on child rights, not merely stressing on different legislations, but also on understanding childhood, adolescence, and related vulnerabilities, child psychology, and tools and techniques for communicating with children. Standardized methods and tools and also technology can go a long way in eliminating data discrepancies and improving data management steps. No doubt, we have a collective responsibility in this regard. To conclude, I'd like to acknowledge the efforts of Juvenile Justice Committee of Gauhati High Court, UNICEF, and representatives of various line departments, police, civil society organizations to reach out to key stakeholders and duly bear us to seek feedback on the challenges and in identifying the bottlenecks in implementing special laws and addressing crime against children. I am sure the findings of this exercise, along with the secondary data analysis, will make a significant contribution to enriching today's discussion and support us in developing child-friendly policy in the state that safeguard the best interests of the children and provide safe and protective environment for all children to enjoy their childhood. With these words, I wish this consultation a great success. Thank you.
Thank you so much, ma'am.
The keynote address will now be delivered by Honorable Mr. Justice N. Koteswar Singh, Honorable Chairperson of the Juvenile Justice Committee of the Gauhati High Court.
Good morning to everybody present here. Whenever I address any gathering relating to children, I am always tempted to quote a few lines from the poem of Rabindranath. On the seashore of endless worlds, children meet. They build their houses with sand and they play with empty shells. With withered leaves they weave their boats and smilingly float them on the vast deep. Children have their play on the seashore of the worlds. They know not how to swim. They know not how to cast nets. Pearl fishes dive for pearls. Merchants sail in their ships, while children gather pebbles and scatter them again. They seek not for hidden treasures. They know not how to cast nets. See, there's the world of the child, the children. Suddenly it's traumatized by this assault, by these who are supposed to be the guardian, the protectors, the guides. That's the environment, that's the situation which we are called upon to deal with. Respected Srimati Ajanta Niyogji, the Honorable Minister, Women and Child Development and Finance, Government of Assam, respected Sri Alo Libang, Honorable Minister, Women and Child Development, Government of Arunachal, respected Mukesh Chandra Sahu, IS, Principal Secretary, Department of Women and Child Development, Government of Assam, my esteemed colleagues from the bench of the Gauhati High Court, all the participants ranging from the judges, the lawyers, the stakeholders, various NGOs who have played a very important role. Didn't mention Madam Mukesh Chandra's, Madam Madhulika Jonathan and of UNICEF, who has played a very important role. In fact, I remember since I became a judge, we have been holding a number of consultation programs across the country, regional level. I had the fortune to take part in a number of occasions held with UNICEF, which has played a stellar role. And all the various participants who are present today. Yes, as mentioned also by Madam Madhulika Jonathan, Chief of the UNICEF for the Office of Assam and the Northeastern States. As per the data collected by the National Crime Bureau, in the year 2019, the crime reported against the children in the entire country was 1,48,90. In 2020, it was 1,28,351. Sorry, that was in 2019, and it was in 20. It was 1,28,531, which was increased to 1,49,404 in the year 2021, out of which about 30 to 36% were sexual offences against children. The figures in the earlier years were equally disturbing. And according to a survey conducted by the World Vision 2017, 1 in every 2 children is a victim of sexual harassment in India. Unfortunately, as also mentioned by Honorable Minister from Arunachal, in majority of the cases, the perpetrators of the crime are familiar to the victims, thus creating a huge trauma in the children, and of course their reluctance to disclose these crimes, it resulting in many of the crimes being unreported, therefore not investigated, and therefore not punished. Thus, with such large instances of crimes committed against children, a comprehensive response to deal with this, such a menace was felt necessary. Of course, in India, it is not on the moral obligation to keep children everywhere, but there is a legal and constitutional obligation as well. Article 15 of the Constitution of India, it enables the state to make special provisions for the children. Article 39 of the Constitution of India, which is the directive principles of state policy, obligates the state to direct its policy towards securing that the children are not exploited and are given the opportunities to develop in a healthy manner. This, our country also ratified the United Nations Convention on Right to Children in the year 1992. Therefore, we had an obligation also that, as per directive state policy also, it obligates the state to honor international instruments, conventions. Now, fortunately, after about 20 years of the ratification, we have been able to evolve a comprehensive legislation to deal with various facets of this crime involving children by enacting this Protection of Children from Sexual Offences Act 2012. This act would enable us to face the multifarious challenges in the justice delivery system while dealing with sexual offences against children. This act has been enacted to make the justice delivery system more responsive to the needs of the children and to create a child-friendly and more amiable, informal and conducive atmosphere, divested of the formal and sometimes very intimidating atmosphere of the court. I would like to mention also that even before this act was enacted in 2012, the Juvenile Justice Committee, which we are functioning, these were created on the basis of a resolution taken by the Conference of the Chief Justices in 2006. We have the Supreme Court Juvenile Justice Committee and all other High Courts Committee to monitor or to contribute as to how to meet the challenges even before the act was enacted. As we know, while dealing with crimes under a penal code or any such statutes, once a crime is reported, it becomes the exclusive domain of the investigators. The court does not also interfere, normally does not, except in rare cases. Then once investigation is over, is handed over to the court, then it becomes the exclusive domain of the court, the judges and lawyers. But when we are dealing with the crime, the sexual offences against children, while these two agencies remain, they continue to play a vital role. We see a multifarious agencies which come into play. Right from the stage of reporting, in fact, that a departure under the normal criminal jurisprudence, only when a crime is committed and you go and file a complaint. But under this act, you can file it even when you apprehend that is likely to take place. For example, I was just remembering yesterday when I went to Goa some time back. I saw in a swimming pool on foreigner was that two small girls were swimming with him. I was not feeling comfortable. Of course, that was about 10 years before. I was not feeling comfortable. Perhaps if the act was enacted at a time, maybe I could have gone and said, well, I think there's something wrong. This foreigner swimming in this swimming pool of this resort with his two children who does not appear to be very well to do. And something I was not feeling good. So, not that you have to report it after the crime is committed. If you apprehend that yes, a sexual offence is likely to be committed, you can also file a. So this is a very unique kind of statute to meet this unique situation dealing with children. Then apart from the normal police station, we have these special juvenile police units who are trained to deal with this. And also, and also we have the moment we see the child is being brought, a victim is brought. If the court feels, or the investigating authority feels that there is no proper domestic support system, obviously the child has to be, especially a child, girl child, especially has to be referred to the CWC. Now, another agency which has been created under another act, under the JJB Act, gets activated. If CWC is activated, the whole process, the various agencies which are functioning under the JJB also gets activated. For example, the Child Welfare Police Officer, the District Child Protection Unit, the Child Welfare Officer, the Probation Officer, Special Educators, Support Persons, Social Workers, various institutions, they immediately come into play, which is not normally there when we deal the normal crime. Now, even during the investigation as well as during the trial, there are special provisions enacted. There is provision for taking help of translators to deal with children who are not able to explain properly what has happened, or witnesses also. Is not only the victim, but also witness who can be traumatized. A friend of this child, when he or she finds his or her friend being brutally assaulted, so she also gets equally traumatized. They don't speak out. So these are areas where special educators, these interpreters are required to be utilized by the court as provided under Section 38 of the Act. Now we have also vulnerable witness, because the child will not speak up even in the court. We have, fortunately, the Supreme Court has taken a lead in this, and we have a scheme under which we are required to prepare this the court room in such a manner that the children, especially the child witnesses, or any such vulnerable persons, they can depose in the court in a very free and frank manner. So we have the whole scheme coming up. And as far as, of course, the Act does not provide specifically for protection of witnesses, but it is inbuilt. We are all aware of the NALSA scheme also there. I think the honorable judges who are here must keep in mind that merely because the Act does not mention specifically of the protection of witnesses, please keep that in mind, because they are most vulnerable. They may be under attack. They may apprehend that they will be further victimized by the persons, or their relatives. So these are areas where the judges have to take much more care. And of course, the role of these various other agencies, NGOs, professionals, experts, wonderful. I mean, we are happy to be here. UNICEF is of course there. UNICEF is not an NGO; it's a multinational body. But then we have seen the experts coming here, sharing their ideas, views. They have also contributed a lot to make this justice delivery system more understandable, and how to work this situation, because they have worked at the ground level. So they have understood the various problems which are facing. I am sure the judges, the lawyers, all the other stakeholders who are involved directly, who are statutorily appointed, should take the experts' ideas much more seriously. That's how we can improve upon the working. And then the whole regime of this medical examination. Unfortunately, from the list I see, I don't see any doctor, which I feel a little bit disappointing. I was expecting some of the doctors. Yesterday also there were discussions on all these 2 fingers and all this. No, representatives are there, but yeah, I understand. But if more doctors who are directly in the field are also, oh yes, madam, you are there. Oh, wonderful. Yes, you're there. Wonderful. But I wish, because these are areas, because I see this 2-finger theory still going on, as mentioned also, which has been banned by the Supreme Court. It's not appreciated anywhere else. Then in fact, the whole, if you read our rules, just to mention, detailed provisions have been given of medical aid and care under Rule 6 of the POCSO Rules 2020. How to deal with traumatized, not only that, immediate relief, how to get them treated, how to admit. Doctors are wondering where to get them admitted, who will bear the cost. Well, everything is given here. The doctors don't have to worry about the cost. It is their not only moral obligation as doctor, but the legal obligation under the Act and rules to see that the children that traumatize the victimized child gets immediate medical attention to the best facility possible. And there is another area which has been also highlighted yesterday about this determination of the age. Because see, what this POCSO Act has a special provision under Section 29. Under normal criminal proceedings, an accused is deemed to be innocent till he is proven guilty. But in a POCSO proceeding, the moment charges are framed and the trial starts, then it shifts. Then accused is put to a very difficult position. That there is a presumption that he has committed this crime. But then, if we ultimately find, which we have found in our cases, that we had to set aside so many proceedings because we found that the children, the victim was not a child. The entire trial goes to who suffers. The child suffers because she has not got the justice, and the accused also has suffered because he had to go through. We do not know whether he is the actual perpetrator of the crime. He gets scot-free. The society suffers. And when the society is looking at the system, the society feels that yes, we say this, yes, this fellow is responsible for this crime. And they see that after 5-6 years, this accused goes scot-free. How do we do legislation? Very, very important. The most perhaps important in a POCSO case is determination of age. The IO, yesterday also I have heard some experts also mentioning, is important. They must find out the evidences. You can't just see from the face that yes, just because the mother or father says no, she is a minor, no. There must be legally admissible evidence to show that the victim is a minor. The judge must also do it. And judge must do it on the basis of the JJB provisions of the JJB Act. And most of the POCSO judges who are the grade 1 officers, they have not dealt with JJ Act. They don't deal with JJ Act. But then you have to get acquainted with the JJ Act because the determination of the age of the victim is to be based on the basis of the provisions of JJ Act. Therefore, what I am trying to emphasize is that in a legal system dealing with the sexual abuse of children, the whole host of various other elements which are not normally dealt with under normal criminal gets activated. What I am trying to say is that yes, it is a multi-agency exercise. Obviously, it requires proper monitoring. There the role also of the NCPCR and the SCPCR comes into play. The Act mandates, the rule mandates. Fortunately, we are here because of the decision of the Chief Justice's Conference. Otherwise, we don't have any statutory mandate to hold this entire process. It is basically the NCPCR and the SCPCR, which is to monitor as we understand the various socio-economic reasons which contribute to the commission of such crimes. And it is not very easy, as people have mentioned today also by all the speakers. Awareness is very important. The awareness amongst the people, because yes, all this love kind of stories and all this thing coming up. I mean, you don't fall in love and do all these things, when you are a child or when you are studying. They have to be made aware the implications of these legal provisions. It is important that I feel that the most important perhaps is to have this coordination among various, because, and as you say, the judges, they function in the High Court, the lawyers, the prosecution under the government, and the various stakeholders under perhaps the social welfare. The NGOs are not under anybody, the experts. So we have these multifarious agencies under different controlling agencies. How to coordinate, work in a cohesive manner is perhaps one of the most challenging tasks before us. We can have hundreds of training programs for the honorable judges here. But what about other stakeholders over whom we don't have a direct, supervisory power or control or authority? Therefore, there has to be somewhere this element, and of course it cannot be forced. You can't bring all the stakeholders under one authority, except even this NCPCR and SCPCR only to monitor how it is effectively monitored. But this is the only process. Consultation process is a key. As I mentioned yesterday also, it need not be only yearly or annual or biannual. It must, I personally feel that it must be at least bi-monthly to see where we stand, what are the problems we face at the ground level. This is perhaps one of the important issues which has to be considered. Yes. How, for example, I mentioned, is there any SOP for emergency medical treatment? And as per the rules, as per Rule 5 of the POCSO rules, the DCPUs are to maintain a list of persons, experts, and share. I don't know. Any DCPU could tell us whether you have maintained any list. Then you share with the police, you share with the doctors, or you share with the courts. Rule 5 mandates the DCPUs to prepare the list. I don't know. If it is prepared, very well, thank you very much. But if it is not prepared, it must be prepared. Because that's how the court will also understand who is doing what. They can contact also. The police also can see what any particular person has done their job or not. So these are all coordination. Idea is to coordinate. Coordinate in a more cohesive manner. That's the key to the success of this, I think, the regime. Otherwise, if everybody is kept aloof, doing their job without coordination, that will be a big challenge to the effective implementation. In this regard, in fact, it's a great satisfaction that I think the 100% attendance of those who have been requested to attend, and of course, in this regard, the state government and UNICEF have done a wonderful role. I must personally thank for the trouble we have taken to ensure that all the participants come in time, they stay in the comfort, and have good food also, and it is meeting venue, wonderful. Thank you very much for arranging this. Yes, I know Mr. Principal Secretary himself had taken a very important role. Mr. Partha Pratim also, Majumdar, Member Secretary with State Child Protection, and Lakshmi Nandan also. They have played a very important, they have been working, behind the scene. Of course, not at our registry, Mr. Tapadar also, our legal services also, Member Secretary, they were all in the picture, working together in a coordination to make this consultation process a success. And of course, I must thank personally Honorable Ministers from Assam as well as Arunachal. Your presence here is indeed very inspiring. I'm sure it will inspire the stakeholders also. Your personal interest I'm sure will percolate down to the various stakeholders who are working under you. And I'm sure they will not hesitate to approach the minister as and when any issues crop up. Well, I must thank everybody here for giving a patient. I think I have overshot my time, but thank you very much for giving your attention, and also to able be to share some of the thoughts which came up in course of my membership of this committee, and also after interacting with various stakeholders. Thank you very much.
Thank you so much, Your Lordship.
Shri Rafiq Ahmed Tapadar, Secretary Juvenile Justice Committee, Gauhati High Court, is now requested to deliver the vote of thanks.
Thank you, sir.
Nice. Nice. I'm so happy.
Very good morning.
Because your presence makes
Honorable dignitaries on and off the dais,
these are the officials.
ladies and gentlemen,
the fact that
it is indeed a pleasure to propose the vote of thanks to all those who have contributed in one way or other towards the state-level consultation on implementation of POCSO Act. Ladies and gentlemen, at the outset, I express my gratitude to Honorable Mr. Justice R.M. Chhaya, Chief Justice Gauhati High Court, for his Lordship patronage in this very important program. His Lordship, although not present today, has supported us immensely and provided us with all the necessary support in organizing this consultation. I sincerely wish to thank Honorable Mr. Justice N. Kateswar Singh, Chairperson, Juvenile Justice Committee, Gauhati High Court, for being the guiding lamp. His Lordship has guided us in the effective implementation of children laws in all 4 states under the jurisdiction of the Gauhati High Court. Lordship has also illuminated us with his enlightening speech today. Thank you, Lordship, for your guidance. My heartfelt thanks to Honorable Srimati Ajanta Nyo, Minister, Women and Child Development, Finance, Assam, for being a pillar of strength in various initiatives undertaken in the realm of juvenile justice delivery system in this part of the country. I also express my sincere gratitude to Honorable Mr. Alo Livang, Minister, Women and Child Development, etc., Arunachal Pradesh, for encouraging us by his gracious presence in these plenary sessions. My thanks also goes to Honorable Mr. Lanu Sungam Jamir, Honorable Mr. Michael Jotang Kuma, Honorable Mr. Justice A.M. Gujar Barua, Honorable Mr. Justice Sumitra Soikia, Honorable Mrs. Malasri Nandi, who are the members of the Juvenile Justice Committee, Gauhati High Court, for their Lordship's necessary support and guidance, and for being the driving force behind the whole process. I would like to take this opportunity to express my profound gratitude to Honorable Mr. Justice M.R. Pathak, Judge in Charge Training, and Honorable Mr. Arun Dev Chaudhary for their gracious presence and for sparing their valuable time for this plenary session. I also wish to thank Honorable Mr. Justice Retired Mir Alfaz Ali, Director, Judicial Academy, Assam, for guiding us in this consultation. My sincere thanks goes to Mr. Mukesh Chandra Sahu, Principal Secretary, Department of Women and Child Development, Government of Assam, Dr. Madhulika Janathan, Chief UNICEF Office for Assam and Northeastern States, Mr. Partha Pratim Mujumdar, Member Secretary, State Child Protection Society, Sri Lakshmi Narayan Nanda, Child Protection Specialist, UNICEF, for their proactive and very supportive role in organizing this consultation. I express my admiring deference to the resource persons of this program, Ms. Preeti Patkar from Prerana, Mumbai, Mr. Vipul Yas, Profession in the Foundation, Mrs. Indrani Borua, IPS, DIG CID Assam, Mr. Miguel Das Kua, Utsa Child Rights Organization, Ms. Gitanjali Ghosh, Assistant Professor in Naluja, Mr. Devashish Sharma, Principal, Police Training College, Dergaon, Mr. Anand Kumar Astana, who will address us today, Ms. Swagata Raha, Director and Fold, she is present here today, Dr. Jagdish Reddy, and Dr. N. Janardana from Nemans. I owe special gratitude to the officers and staff of the Women and Child Development Department, Government of Assam, State Child Protection Society, Assam, and UNICEF for looking after all the technical aspects of this initiative. I also offer my thanks to Registrar General, who is not present here, although all the registers, all the officers and staffs of the registry, members of the Juvenile Justice Secretariat of the Gauhati High Court for their kind cooperation and hard work in making this program a success. I also thank the registers of the outlying benches, members of the secretaries of the state legal service authorities who acted as coordinators for these consultations. I also like to thank the secretaries of various departments who are present here, most likely for the Education Department, Social Welfare, Women and Child Welfare Department, Health Department. I also like to thank Mr. Makhan Fukan, Public Prosecutor, Gauhati High Court, learned POCSO judges, learned judicial officers of Assam, Nagaland, Mizoram, and Arunachal Pradesh, senior police officers from the 4 states, public prosecutors, members of the Child Welfare Committee, DCPOs, the representatives of the state child protection societies, representatives from different governments, police departments, from the state of Assam, Nagaland, Mizoram, and Arunachal Pradesh, representatives of State Commission for Protection of Child Rights, representatives from medical colleges, representatives of NGOs for participating in this program. As a parting note, I would like to thank each one of you who has contributed in organizing this consultation, although I could not name them for paucity of time. Thank you. Jai Hind.
I now request all the dignitaries and guests to kindly, first of all, proceed downstairs for a group photograph, which will be followed by a tea break. The panel discussion will start in 30 minutes. Thank you.
थोड़ा प्रोसीड कीजिए फोटोग्राफ के लिए प्लीज।
Arunachal state is the largest in geography. Geographical area is larger. I have been all the sites. I will be that all the interior. My connection that we are the Chinese border right with there also. All that side is still also. I know, that's when I was going. It's such a I think we are still people just meeting those people. Okay, no problem.
Welcome back, ladies and gentlemen. I would like to request Honorable Mr. Justice N. Kotishwar Singh, Honorable Chairperson, Juvenile Justice Committee of the Gauhati High Court, to chair the panel discussion. We also have with us M.S. Swagata Raha, Director and Fold Proactive Health Trust, Bangalore, and Dr. N. Janardana, NIMHANS, Bangalore. They will now be felicitated by the members of the Gauhati High Court Registry and the Department of Women and Child Development.
Mr. Ananta Kumar Asthana, Child Rights Lawyer, Bar Council of India, and member, NHRC appointed Core Group on Children, will be speaking online on the topic 10 years of implementation of the POCSO Act 2012, National Perspective, Trends, Gaps, Challenges, and the Way Forward.
Honorable Justice N. Kotishwar Singh, Chairperson of this panel, my fellow panelist, Ms. Swagata Raha, Dr. Jagdish Reddy, Dr. N. Janardhan, and others in the audience, officers of the 7 northeastern states, brothers and sisters. After 10 years of POCSO, we have seen 4 amendments. First one was in year 2013. The second amendment we saw in year 2018. And 2 amendments in year 2019. In addition to these 4 amendments in the Act itself, we also saw a complete reenactment of model rules of POCSO rules, which were comprehensively revised in year 2020. This itself shows the nature of challenges country has been facing in the rollout of POCSO. These amendments in the Act, in the rule, they demonstrate the evolutionary nature of law. The proposal looked at these changes will also tell us that several implementation related issues, several legal issues, and also several challenges faced in the society with regard to protection of children from sexual offences is continuously on the focus. This series of consultation in years of POCSO provide us an opportunity to take back and do a stock taking of where we are, what are we doing, what are the problems we are facing, and also what we need to do. In this regard, I will be sharing my brief views with all of you for your consideration. With the permission of Honorable Chair, I wish to present before all of you first a brief landscape of what we are talking about. We are talking about 46 sections of POCSO Act. We are talking about one schedule which is appended to the POCSO Act. We are talking about 13 rules in the POCSO Rules 2020, and we are also talking about two forms, Form A and Form B, which have been prescribed by the POCSO Rules 2020. In addition to this, we also have to look at two more documents which are in the nature of law. One is model guidelines issued by the Ministry of Women and Child Development under Section 39 of the POCSO Act. Many of you may be aware that these guidelines were issued by the Ministry of Women and Child Development, Government of India, soon after the Act was enforced. Act was enforced on 14th November 2012, and these guidelines were rolled out by the ministry as model guidelines in September 2013. Not even a year passed. What are these guidelines? These guidelines are very important. These guidelines provide us a framework as to how various stakeholders will perform their functions. I was listening to Honorable Justice Sam Patiswar in the previous session, and one of the concerns he raised was regarding a huge range of stakeholders being involved in implementation of POCSO Act. And the concern my Lord was sharing was, is there a uniform accountability mechanism for all these stakeholders? We may not have a uniform accountability framework, strictly speaking. In the form of these model guidelines, we do have a broad framework. These guidelines deal with various kinds of experts, educators, translators, support persons, which are backbone of the POCSO Act. How will they function? How will they work? Now, what is the actionable for us? The action for us is that these are only model guidelines issued by the central government. They have to be adopted by state governments, and not just a simple adaptation, but required modification considering the local environment, situation and requirements. This will definitely contribute significantly in ensuring better implementation. Second document which I want to draw your attention towards is guidelines and protocols on medico-legal care for survivors and victims of sexual offences. These guidelines and protocols are very much required when we see in individual cases the lacunas and the absence of guidance regarding medico-legal procedures. These guidelines were issued by the Ministry of Health and Family Welfare on 19th March 2014. Of course, a lot has developed in terms of law and procedure since then. These guidelines will also require modification and adaptation by the respective state governments. This is also second action. This will address a lot of problems we face in the hospitals, in the forensic tests, in the kind of processes which IO put in place for evidence collection. Now I come to another aspect. So far, our entire focus has been on offences committed. If we look at section 19 of the POCSO Act carefully, we will notice that POCSO is also requiring, POCSO is giving a mandate to the police to have preventive policing in place. The language of section 19 is that an offence under POCSO has to be reported. Second mandate is that apprehension of an offence under this act being committed also needs to be reported. One may ask, what is the need for reporting an apprehension? The need is that we don't have to wait for an offence to be committed. Law has created a duty on the citizens to report to the police if they suspect that an offence may be committed. Our entire focus has been on the offences committed. I think now at the 10th year, we will be well advised to look at what kind of procedures can be laid out by the police with regard to giving effect to the reporting which is to be done concerning possibility of an offence. Preventive policing on child safety is the mandate of POCSO Act. This I wanted to flag for your kind consideration as we move forward. Honorable Justice N. Patiswar was also sharing another concern regarding various stakeholders not exactly being under the government supervision and control. The concern is shared by many of us. I want to draw your attention to how POCSO Rules 2020 have addressed this. If you look at Rule 3, Sub-Rule 5 of the POCSO Rules 2020, this rule has prescribed state governments to formulate child protection policy for all stakeholders who engage with children in contact with them. Child protection policy by the state government. This will provide a supervision regulatory framework for even non-state actors to engage with POCSO Act. Third issue which I want to flag here before all of you is our preparedness regarding children court. Children Court was created under CPCR Act 2005 for dealing with offences against children. And please take note, not only sexual offences. 2005, it's a pre-POCSO legislation. Commission for Protection of Child Rights Act 2005. It created Children Court. Children Court includes POCSO Court. Children Court includes Children Court. Children Court is also the same court which hears and decides appeals under JJ Act against the orders passed by JJPs and CW. Children Court is also the same court where children in conflict with law are referred for adult-like trial. So 4 jurisdictions. We have to strengthen our children court. But our children court has got huge jurisdiction. Only with respect to children. So our perception of POCSO court, administrative arrangements around it, workflow, how they function, how they are created, does not remain only with regard to sexual offences. Time has come that the POCSO courts are seen from a comprehensive vision of a wider legal framework where we take into account the mandate of CPCR Act, we take into account the mandate of JJ Act, and accordingly we strengthen the institution of children court that automatically includes POCSO. While the entire focus goes on children court, POCSO court, it's also very important, and I'm flagging it here, that a large number of children, either as victims or as perpetrators under POCSO Act, come before juvenile justice courts. Our juvenile justice courts deal with POCSO cases. They have to also enforce provisions of POCSO Act. The entire range of the entire range of procedures, powers which are available to POCSO courts are also available to the Juvenile Justice Board when the matter relates to children in conflict with law who are alleged to have committed offences under POCSO. What I have noticed is that a lot of attention is going on POCSO courts, children court, and that is why I thought that I must flag this concern regarding also keeping in view what's happening in the juvenile justice boards, happening to the children who are being taken to juvenile justice board under POCSO Act. And now I come to my last submission for all of you is that on the 10th year of POCSO Act, you have to acknowledge and recognize that the rolling out of POCSO Act requires a very strong convergence between judicial systems and child protection systems. And a lot of effort is required for children courts, POCSO courts to be mainstreamed within child protection system, the way it has happened in regard to juvenile justice courts under the JJ Act. For a very long time, juvenile justice boards were seen only as judicial bodies, as part of judiciary. Though they were created under JJ Act, but they were seen as part of judiciary. Child welfare committees were seen as part of child protection system. Now, all that has developed. Now the NPS are seen as part of child protection system. Similar thing has to happen in regard to our judges who preside over these courts have to make a journey little bit out from conventional protocol of higher judiciary. Children quota session judges, POCSO quota session judges, they may not be very comfortable working with administrative and government departments. But the law requires them to engage with child welfare committee, district child protection unit, in a way which is very different from a judicial functioning. So some orientation has to change if POCSO Act, because POCSO Act requires not only court to do trial, also facilitate care and rehabilitation. I think with this, I will end my submission here and hand over the space to the coordinator of this section and to the honorable chairperson of this section. Thank you, my lords.
Thank you so much, Mr. Asthana.
Next, I would like to request MS Swagataraha, Director Enfold Proactive Health Trust, Bangalore, to speak on presentation on analysis of special POCSO court judgment on romantic cases in Indian states, with special reference to Assam.
Honorable Mr. Justice N. Koteswar Singh, Chairperson of the Juvenile Justice Committee of the Gauhati High Court, my fellow panelists, dignitaries of the dais, esteemed judges, participants and delegates from the 4 different states, as well as civil society organizations. At the outset, I would like to express my heartfelt gratitude to the High Court of Gauhati, the Juvenile Justice Committee, the Department of Women and Child Development, as well as UNICEF Assam, for enabling us to have access to people working on the ground and their experience of dealing with romantic cases. It's been 10 years since POCSO came into existence, and in the course of our direct work with children entering the juvenile justice system as well as the criminal justice system, and our interactions with various stakeholders, we realized that there was a significant number of cases of children coming into the system where they were in a quote-unquote consensual relationship. It was with this intention that we decided to gather evidence as to what is the extent of these cases in the criminal justice system and how are these cases then being dealt with by the system. So for the purpose of this analysis, we looked at 3 different states, Maharashtra, West Bengal and Assam. And today I present to you the findings of the Assam data. Yeah, thank you. So for the purpose of this analysis, we defined romantic cases to mean cases in which the victim girl at some point in time in the journey within the criminal justice system had admitted to being in love with the accused or in a consensual relationship with the accused, or her family members or other prosecution witnesses have stated this in court, or the special court has arrived at this conclusion irrespective of whether or not the girl expressly stated this. We, however, excluded cases where only the accused claimed that it was consensual. We also had to exclude cases where the child in conflict with the law was the person with whom the victim was in a relationship with, and that inquiry was pending before the JJB, but the adult accused were charged with abetment. We also excluded cases where there was elements of elopement. The facts did suggest that it was a romantic case, but there was no express reference to it by any of the parties. For the purpose of the analysis, we essentially drew cases from the eCourts website. We downloaded 7,560 judgments over a 5-year period, 2016 to 2020. And after further pruning, we arrived at 7,064 judgments that were under POCSO. Within this, we, based on our criteria, we found 1,715 judgments that constituted a romantic case, of which 341 were from Assam. These judgments were then subjected to qualitative as well as quantitative analysis on certain key questions of inquiry, which we will now share with you. The first thing we wanted to understand is what is the proportion of these types of cases in the total number of cases that are being disposed by courts. And we found that in Assam it was the highest. It was 30.1%, whereas in the other 2 states you can see in Maharashtra it was 22.8, 25.8% in West Bengal. We were curious to understand why and how are these cases entering the system, and this is the data affirms what the practice is on the ground, which is that majority of these cases are set into motion by the family members of the girl. Excuse me. Collectively, 89.8% of the informants were parents of the girl and relatives of the girl. The girls themselves approached the police in 9.1% cases. And when we examined the background of these cases, we found that these are cases in which the accused refused to marry the girl or went on to marry somebody else. Very few cases were of a nature where the sex was non-consensual. And there were also cases where there was pressure from the family or the community to lodge the matter. Now, what are the circumstances that are responsible for the lodging of the cases? We found in 13.8% cases each, there was a pregnancy that ultimately led to the lodging of the case, or that there was a breach of promise to marry on the part of the accused. And majority of the cases were lodged when the girl went missing or she eloped with the accused. So this category constituted 65.4% of cases. Now, in the reading of the judgments, what we also saw that in certain regions in Assam, it was apparent that the police was approached by the families only when a village level settlement could not be arrived at. What prompted the girls to leave home? And this is also something we wanted to understand. Why is it that the girls are being forced to leave their homes with their partners? And this reasoning was not available in all judgments, but in the few cases that it was, the dominant reason was, of course, the fact that the parents did not approve of the relationship, or that there was arrangement of another marriage, or that there was some violence that the child was facing at home. Now, moving to the kinds of charges that are seen in cases like this, we found that 95% of cases had a penetrative charge. And as we know, following the amendment of 2019, we are looking at a minimum sentence of 20 years if it is aggravated penetrative sexual assault, or 10 years if it is penetrative sexual assault. As we know, a significant feature of romantic cases is the aspect of elopement, and we see that in 61.3% cases, a kidnapping charge was also included with the POCSO Act. Coming to the gender and marital status of the parties, all the victims in our set of cases were girls, and all the accused were males. Now, when it comes to the marital status, we found that 40.8% of these parties were married to each other, of which majority of these marriages took place after the case was initiated. When we contrast the conviction rates in this type of cases, we found that it was much lower. Only 2.9% cases where the parties were actually married was a conviction recorded, and in many of these cases, judges articulated that they did not want to disturb the marital relationship of the parties and therefore decided not to proceed with the conviction. Of course, there were other factors too, such as the victim not testifying against the accused or the victim's age not being established. Now, with respect to the age factor, as Justice Singh was also saying in the morning, age determination is a very key aspect of POCSO. We found that age-related data was very scanty in judgments in Assam. So based on what was written, and this could only be gleaned from what is written in the text of the judgment, we found that a majority of the children were between the 16 to 18 years age category, but at least in 49% judgments, there was no reference to age at all. Now, in cases where we did find a reference to age, we saw that there was contest, not only that the defense is contesting the age of the victim herself is claiming to be a major, whereas her parents are claiming that she's a minor. So we saw in 33.6% cases in which the parents claimed that the girl was a minor, she stated that she was an adult, possibly pointing to the potential use of the POCSO Act by parents to control and regulate the sexuality of their daughters. Coming to the conclusion of the special courts on the victim's age, here we found that in majority of the cases, the victim's minority could not be established by the prosecution, and that was about 52% cases. It could be established only in 13% cases, and in 34% cases, there was no determination by the special court of the age of the victim. Again, when we decided to understand why this is the case, we found that in 90% of the cases in this pool, that is the age not determined, excuse me, the victim had not testified against the accused. And it is possible that this may have then resulted in the court not entering into the question of what her age might be. With respect to what the victim is saying during her journey in the criminal justice system, we found 90.9% cases where the victim expressly admitted that she was in a relationship with the accused, and this admission was either during her 161 statement, 164 statement, during her medical examination, and of course during the stage of evidence. Now, coming to the manner in which these girls testified, we found that in 79.8% cases, the girl did not say anything incriminating against the accused. Whereas in a very small number of cases, 18.8%, the girl testified against the accused. Now, this obviously had a direct impact on the outcome of the cases, and we find that acquittals were the norm, with acquittals being recorded in 94.1% cases in Assam and a conviction rate of only 5.9%. In our view, this points to the consideration of the social realities of teenage sexuality by the judges of the special courts in Assam. And in 52.3% cases, we also found that the special courts expressly acknowledged that the relationship was consensual between the parties. Now, these cases are also consuming a significant amount of judicial time, and here we find that majority of these cases took more than a year to be disposed, with 33.7% being disposed between 1 to 2 years, and the median time being 1.4 years. This also means that there is prolonged detention of the accused persons in these cases. Although it may result in acquittal, it does not mean that they are not subjected to the harsh nature of the judicial system. Finally, what the findings compel us to look at is to question how and by whom is the POCSO Act being used and for what purpose. Is it to protect adolescents from violence, or is it more to regulate their behavior, and what might be the impact of such criminalization on their rights. Their right to development, dignity, liberty, best interests, privacy, and health. Second, the criminalization is also detracting from the purpose of the POCSO Act, diverting time, resources, and energy away from the investigation and trial of actual cases of sexual violence and exploitation, because even though prima facie these cases do not entail any element of exploitation, they have to go through the entire cycle of investigation and trial. Third, we feel that there is a need now to re-examine the age of consent for sexual activity in India, with a view to ensure that there is balance between protection of adolescents from exploitation as well as an acknowledgement of their normative sexual behavior. Finally, in the interim, till such law reform takes place, can we consider what might be some measures that can be taken to reduce the harm that is caused by criminalization when institutionalization naturally follows such criminalization. There have been strategies that have been adopted by some states to avoid apprehending a child in conflict with the law, where it is apparently a consensual case. There has also been an example of use of Section 41A of the CRPC to avoid arresting an adult accused where the parties are married and the girl is pregnant. So there are a variety of strategies that have been used across the board. Even CWCs have adopted strategies whereby they do not necessarily institutionalize girls who are found to be involved in these cases. So with that, I would like to stop here and would look forward to questions around this particular study. Thank you.
Thank you so much, MS Raha.
Dr. Jagadish Reddy, Department of Forensic Medicine, Vaidehi Institute of Medical Sciences and Research Center, Bangalore, will now be speaking online on importance of medical examination and forensic lab under the POCSO Act.
Honorable Chairperson of the Juvenile Justice Committee, Justice Kutishwar Singh, my fellow panelists, and dear delegates of the state-level consultation on POCSO 10 years. I would be speaking now on the importance of medical examination and forensic lab under POCSO Act. You just heard even Astana speaking about the guidelines from the Ministry of Health and the uniform requirement of medical examination across the country. So keeping that in mind, the medical examination under POCSO Act is for two purposes. One is for the therapeutic care and the other is for evidence collection. And we are looking at both the victim and the accused. And we have enough legal provisions looking at the victim examination, the section 27 of the POCSO, read with again 164 years CRPC. We have again Rule 6 of the POCSO, especially mentioning the scope of the medical examination, and the section 357C CRPC. For the accused also, we have a specific section looking at the medical examination, that is section 53A CRPC. What we look out as a comprehensive care, particularly for all sexual offences, including POCSO Act, there is emphasis, legal emphasis also. If you look at subclass 164 years CRPC, it's very clearly explicitly asking for, without consent, it would be illegal to do a medical examination. We need to address the contraceptive as well as the pregnancy-related issues if that is the end result. We all have understood that every case of sexual violence would have psychological consequences and not be a medical examination without addressing that. And there would be a risk of sexually transmitted infection, and there would be a need for a follow-up examination as part of the medical examination in few cases. Again, the medical examination, particularly on sexual violence, was the talk of the entire country. Though the two-finger test is banned, Section 53A of the Indian Evidence Act is very clear, saying that the past sexual practices of the woman are not at all material to the current case of investigation of sexual violence. But unfortunately, this continues. In 2013, the Supreme Court very clearly clarified in the Lido alias Pradesh case that the two-finger test violates the right of the rape survivors to privacy, physical and mental integrity and dignity. Again, things did not improve across. Again, just recently, State of Jharkhand versus Shailendra Kumar Rai, the Supreme Court reiterated that time and again we are speaking about two-finger test in cases alleging rape and sexual assault. The so-called test has no scientific basis. It instead re-victimizes and re-traumatizes the woman. And the court went on saying that if this practice continues, so that would be held as a misconduct, and the doctor would be held guilty of misconduct if such is continued. So I am placing it across on record so that this practice should stop across all the hospitals of this country. The next part of the medical examination would be the scope of termination of the pregnancy. We had varied judgments across the country, whether to terminate, not to terminate in a sexual violence case. At last, the legislature in 2021 brought out the amendment, and we had the rules notified in last October of 2021, which elaborates till 24 weeks for those cases which fit in the special categories under Rule 3B of the 2021 amended Act of the MPP Act. So, wherein all the sexual violence cases does fit in and all the minors does fit in, and based on this, we need to carry out the MPP without raising any questions till 24 weeks. But the problem comes again with those sexual offences of a married person, whether it was elaborated till 20 or 24 weeks. The Supreme Court clarified it again in a recent judgment on September 29, saying that it elaborated the definition of woman from not only the cis woman, it included the trans woman also. The decision of the MPP is solely on the pregnant woman. Even it expanded to the unmarried people, though the law was not, so it is now the judicial pronouncement, it enhances to the unmarried. Though marital rape is not an offence, a specific offence in this country, it is still an offence under the rape and sexual assault. Supreme Court recognized, saying that for the case of MPP, marital rape would be still considered, and the woman's decision to terminate such unwanted pregnancy. The extra legal conditions of the documented proof of age, all that is not required, and the confidentiality has to be maintained. It went on exploring, saying that for the purposes of the MPP, even though mandate reporting continues, but if the parent or the child requests that the identity of the minor should be withheld, so the Supreme Court said that every hospital and a doctor should go to an extent to conceal the identity of the minor. The medical evidences is the other dimension what we pick up in the medical examination and POCSO cases. We are looking both from the victim and the accused. The evidence could be from the scene of crime or part of the medical examination. It goes with the famous principle of criminology, the Lugard's principle of exchange. It would be there, but it is only our expertise that we need to pick those evidences in every case. Before I place before what is the current status of the medical evidence, let's understand what's medical evidence in sexual violence or more particular in a POCSO case. In the past, if the medical evidence was negative, the courts were finding it very difficult to convict the person, so such importance was given on medical evidence. But is it the same today? In today's context, if medical evidence is negative, still it could be a case of sexual violence. Why is this so? This is so because the definition of rape and sexual assault that is under the POCSO clauses, it's changed, and we are looking at several cases of a non-penetrative offense which also is a sexual violence now, where you may not have a demonstrable medical evidence. Even if it is a penetration, if it is penetration by fingers or body parts or any objects, then obviously much of the dedicated evidence in the form of semen or spermatozoa doesn't exist. And even if it is penile penetration, it's not necessary that in every case you find semen, because now the 2013 amendment of this section 375 also clarifies that mere touching of the vulva by the male organ is enough to constitute the offense of rape. Same applies over to POCSO. So in that situation, it's not necessary that there should be an erected penis, nor a completed act, nor an ejaculation. And even though ejaculation happens, it may not be present in most of the cases if there is a delayed examination or a condom was being used. So, what's the medical evidence? There are 5 types of medical evidences for you. As on date, I would request all the stakeholders participating in this meeting to take note of this. As on date, we have 5 types of medical evidences available. One is the trace evidence, which we are very familiar from ages. The second is the injuries. The third is the sexually transmitted infection. The fourth is if at all there is a pregnancy and its complications. And the fifth and the most important one, evidence of treatment. So depending on the crime, so you may have trace evidences depending on semen or spermatozoa, fecal matter or saliva, depending on the site of penetration and when this examination gets carried out. The injuries you may figure out ranging from the simplest to the abrasion to the fractures of firearm injuries. But it's not necessary that all the injuries would be there because again we have an amendment in the law. The injuries were part of resistance offered. We tried to look at the previous jurisprudence. There was overemphasis on injuries. Much of it, whenever the victim didn't offer resistance, it was always construed against her. But in the 2013 Section 375, if you look at the explanation 2, it very clearly states just because somebody does not offer physical resistance, so it should not be construed that she has consented to the sexual act. So that means the Indian law now doesn't require resistance injury. Again, medically also we don't find in every case a resistance being offered. So medical statistics go less than 1/3 of cases only you may find injuries. The next type of evidence is the sexually transmitted infection. Again, one of the partners should have been harboring the infection. Then only you would get that. But again, it requires a twice examination, one as immediately and the other after the incubation period. The fourth type of evidence is pregnancy. Again, not every case of sexual violence would lead to pregnancy. This is something I want every stakeholder to understand. All unprotected sex doesn't lead to pregnancy unless until the situation corresponds to the ovulation and there is fertilization of that ova by the sperm and there is conducive atmosphere for implantation of that fertilized ovum, then only pregnancy would happen. Otherwise, pregnancy is not a must in every case of unprotected sexual violence. Evidence of treatment. So this is something which I draw. the above 4 types of medical evidence all have its limitations. Today we have a legally mandated treatment. It's compulsory treatment today. And couldn't we use this as a sort of a record which is available in every case as part of medical evidence? Let me point out that one is the medical records identifying the history that there was pain post-assault. The doctor also identifies tenderness at certain parts post-assault. There is a prescription of an analgesic such as painkiller. There is a proof of consumption of that painkiller. Wouldn't all this mean that there is an indirect evidence of pain post-assault? So it's a corroborative evidence. So similarly for infection, similarly for depression, so if these medical records identify treatment records corresponding to that, wouldn't this be an evidence which is always available as part of medical evidence? I will just present to you as part of the analysis. I would request again the organizers as well as Swalata also to share this, if this is not already shared to the participants, as we should have a detailed analysis of how the courts appreciated medical evidence in POCSO cases. That would give a good insight into what's the status of medical evidence in the adjudication in Indian context. I'll just place before you all that evidence which is in front of you, even tested by the forensic science lab. So I want you to look at whether this lab tested that using a confirmative test, or whether they merely tested with a test which is only of sensitive in nature, or whether they tested with a test which is only specific in nature. Why this becomes relevant in our discussion? If it's a sensitive test involved, suppose I take, so the lab has done a wood slump examination to detect a semen stain. So a wood slump test would identify the fluorescence of a semen stain. So why this is inferior test? This is inferior because wood slump not only detects semen, it would also show fluorescence in many other body fluids like saliva or liquid, or even like antibiotic, lubricant and like. So the inferiority is because it not only detects semen, but it also has several false positive results that even though it was not semen, it should have shown fluorescence. So we need to identify whether the test in front of us is a sensitive test or a specific test. A specific test, even though it was semen, there are certain situations where it is false negative. So that means even though the semen, it might have not picked it up. So we need to analyze the evidence in front of us by the lab, the forensic science lab, is based on what variety of test. Whether it's a confirmative test or a specific test or a sensitive test for all semen, blood, lubricant, hair or likewise. Before I end, I place before you the DNA fingerprinting. I think we are using this left and right in all sexual violence cases. Before we take a call on that, let us look out due to paucity of time, and I'll not go into the steps of that. So we use these techniques to identify the DNA profile of an individual, and that would be in terms of barcodes. And based on that, for our discussion, so suppose we have 2 suspects and we need to identify the child, who is the biological father for this child. So in that situation, so one impression what we need to have is the child would get half the DNA from the mother and half the DNA from the father. So based on this principle, so we have certain barcodes. So those are the short tandem repeats based on which we identify. So the child has these barcodes. So that should have come from half from the father and half from the mother. So for our understanding, I have oversimplified over here. So this barcode is present in the mother, but not there in any of the accused, the suspects over here. So in that context, so this barcode would have contributed from the mother. Then we look at Bob and Larry, who would have contributed. Bob has over here, but the child doesn't have that. So that is one against Bob. Larry has one. It is there in the child. It's not there in the mother. So that means, oh, Larry has one positive confirmation. Both Bob and Larry have these, which is also there in the child. So if you look at the next one, Larry has one. So that means we have three things towards Larry pointing it. So that means we rule out on statistical probability that Larry would be the biological father of the child in this case. So such as on date, we are looking at 16 STR loci in the Indian context, though the West have already gone towards 24. So it's time we also upgrade our things so that the statistical probability of proving who is the biological father would be higher positive scale. There's enough sort of advocacy going on saying that we need to do DNA in every sexual violence cases, but the law also demands these two laws specifically look from 2005 that in every case we need to do the DNA analysis. But unfortunately, if you look at 10 years down the lane of POCSO, so I don't think in every case, in every state, we have this evidence for again the infrastructure issues. All these trace evidence, what we already discussed, could be reused for the DNA analysis. But what we have to remember is a very good test, but unfortunately this is an evidence to compare. If I don't have a comparable evidence sample, so then this test would be useless in our context. Again, we have varied methods of trying to analyze that, and before we get into the final say on that, let me remind the Supreme Court's judgment very clearly pointing it out. DNA evidence is an opinion evidence, and court is not bound by the same. Why the Supreme Court went into such a sort of a decision? We need to look out. If there is a positive match, yes, you can adjudicate the person. But if it is a negative match that doesn't give a clean chit to the accused, you need to look at technicalities for non-matching of the DNA. It could be an improper sample. It could be a sample which the lab took was only from the maternal tissue and not from the fetal tissue. You may argue, how is that possible? So the products of conception at the first month are too small. So in that situation, if the lab not, again, when the doctor terminates that pregnancy, the products would again be pieces. So there could be a probable chance of the lab couldn't pick the fetal tissue and they have taken only the maternal endometrium. Then there is a mismatch, or then there is no match towards the accused or the biological father. So it's only a technicality that you couldn't prove it and it doesn't give a clean sheet to the accused. It could be a denatured sample. DNA is a protein, and protein has a variability based on the heat. So again, if it is exposed to all these, it would get denatured. Contaminated sample, so like if you are careless in trying to pick the DNA evidence, there is enough scope of other evidence or others DNA getting added to that. So those are things we need to keep in mind. And we don't have we don't have the profiles of all the people. We just have started the sexual offenders registry. Again, there are both pros and cons against it. We don't have the DNA profile of all the people in this country. Should we go for it or not? So the DNA database. This act is pending in the parliament for the last 4 years. So again, it is sent to the select panel of the parliament after the Kutaswamy judgment on right to privacy by the Supreme Court. So I think it's very, very difficult for us to be able to get this law passed. But before I end, let me point out another dimension to this DNA evidence. So the Parliament passed this Criminal Procedure Identification Act of 2022, and this law points out whenever it is offences against women and children, these biological evidences can be forcefully collected. So in a country country like India. So how would this be possible? I would leave it to the lordships adjudicating in each case. We are upholding the laws of this country. So how would this be practically possible? So to conclude, in this medical examination, apart from the therapeutic care, we try to look at medical evidence. There are 5 types of medical evidences available as on date: the trace evidence, the injuries, the STIs, the pregnancy. All of these have got limitations. I would request each stakeholder to look at evidence of treatment, which is always available, because the above 4 will have limitations. And so with that, I try to conclude my session over here. And if there are any questions at the end, give time for this. So I'm ready to take that. Thank you.
Thank you so much, Dr. Reddy.
I would now like to request Dr. N. Janardana, NIMHANS, Bangalore, to present his speech on mental health and psychosocial counseling support to POCSO victims, scope, current practices, and way forward.
Good afternoon, participants. First of all, I would like to thank the Honorable Justice N. Koteshwar Singh, who is the chairperson for this session, and also UNICEF and other judicial members from Assam and other neighboring states, civil society members, so NGO representatives, and medical fraternity, for inviting me to share my experience of providing psychosocial care for victims of child sexual abuse. First of all, you would all know what is child sexual abuse. So one person defined child sexual abuse as involvement of dependent, developmentally immature children and adolescents in sexual activity they do not truly comprehend, to which they are unable to give informed consent or violate the social taboos of family roles. So this is the definition given, where we need to give importance in terms of being dependent, immature, do not truly comprehend, and cannot give informed consent. So all these factors would contribute in terms of child sexual abuse, which you all would have been known by now. So what does child sexual abuse includes? So I have given few instances here, where an adult exposing his or her genitals to a child or persuading the child to do the same. An adult touching child genitals or making the child touch adult genitals. an adult involving a child in pornography, which includes showing a child pornographic material, an adult having oral, vaginal or anal intercourse with a child, any verbal or other sexual suggestions made to a child by an adult, and an adult persuading children to engage in sexual activity among themselves, an adult inserting foreign objects into child's body for his or her own sexual gratification. So what I wanted to say from all these instances, forms of sex can be contact or non-contact type of sexes, where it can be penetrative or non-penetrative. A non-contact mainly in terms of exhibition, pornography, verbal abuse. So all those things would constitute sexual abuse, which we all need to look at it. When we talk in terms of sexual abuse, not only just penetrative sex, it can be non-contact also, and in contact non-penetrative sex also, which need to be paid attention when we are working with children. If you have to look in terms of the prevalence of child sexual abuse in India, Honorable Justice N. Koteshwar Singh Sir morning said that over a period of time it has increased. People have more awareness now. People are reporting. These are some of the world statistics what I have been presenting here. But over a period of time, if you look at it, the number of reported cases have been increasing. And we need to be prepared enough in terms of providing intervention for the victims of child sexual abuse. I'm just quoting few statistics here. The Government of India 2007, again a landmark study this one, where it says that 53.22% of sexual abuse found in children. That means more than 50% of child population do experience child sexual abuse. And the peak age what they have found is between 12 to 15 years. Again, there are many other studies which have been conducted. So 2014 study says 28% of them had experienced child sexual abuse. It's a retrospective study where we conducted with college students. So they reported around 28%. And similarly, there are other studies which talks about 42, 33, 47%. The point here what we need to note is the prevalence of child sexual abuse is quite high in the community. So if we now ask the question, why do children do not disclose about the experience of sexual abuse, even though awareness being generated over a period of last 1 decade? There are a lot of other reasons why children do not talk about it. One is it can be fear of losing love of an abuser, and children cannot comprehend what is happening to them, and children also have a limited language ability to express their problems, and scared of abuser or threatened by abuser. It can be scared of an adult reaction on disclosure, because many a time when child disclose, adults would try to shut them rather than allowing them to talk about it. And reinforcements and reward from the abuser, which also attract child to continue or be in this uncomfortable situation. Now, impact of sexual abuse, if you have to look at, it can be physical, psychological, or it can be psychobiological also. So one thing we all need to remember is that the consequence of child sexual abuse, which can be both psychological or physical, but the damaged tissue is likely to be healed without scarring, but psychological consequences may persist with the child for a longer period of time, and hence we need to provide support for these children to come out from this traumatic situation. There are some emotional or behavioral signs and symptoms which we found in children who are undergone child sexual abuse. Among young children, it can be sexualized behavior, where they may show a lot of interest in terms of sex. Sexual advances can be there. Then avoidance of specific adults, having nightmares and sleep disturbances, clingy behavior, separation anxiety, where they are not willing in terms of going out from the parents or going to school, fearfulness and anxiety, bedwetting, school refusal, decreased scholastic performance, and medically unexplained body aches and pains. So when children do exhibit all these symptoms, there is a need for us to probe in terms of child sexual abuse. So how the emotional and behavioral sign would change when they are older children or adolescent? It can be a self-harm. Again, they might experience depression and isolation, anger, outburst, fearfulness and anxiety, sleep disturbances, nightmares, flashbacks, avoidance of specific adults, school refusal, decreased scholastic performance, medically unexplained body aches and pain. Then high-risk behavior, mainly in terms of sexual behavior or substance abuse or running away from home. So again, all this would give us clues for us that there is a need for us to explore with these children, try to find out whether the child has been a victim of child sexual abuse. The clinical conditions associated with child sexual abuse, if we have to understand, it is the fear and anxiety, which is again a diagnosable condition, depression or post-traumatic stress disorder, scholastic decline, encoparesis, then change in sexual behavior, dissociation, borderline personality, substance abuse, and interpersonal problems are some of the clinical conditions we found in these children after they undergo the child sexual abuse. The risk factors, what we have found from various research studies, is that those children who have lack of assertiveness, shy temperament, inadequate sexual awareness and preparedness do have more chances of getting into such problems. Familial factors, if you look in terms of mental illness in a parent or a clinical chronic illness in a parent, can be one of the risk factor. Then poor attachment within a family system, lack of parental supervision, functional absence of parents can act as a risk factor for the children. Socio-cultural, if you look at it, it is more of a disadvantaged living situation, gender discrimination being part of the society where they found more gender discrimination, chances of sexual abuse is also been more. Taboos on sex and sexuality, lack of adult or social responsibility in preparing children for self-defense against abuse. These are some of the socio-cultural factors which can put children under risk. There are some protective factors which we need to identify, and we need to strengthen those protective factors within our society. It can be a satisfactory childhood. So we all have responsibility in terms of making our children to have a satisfactory childhood. So we need to work towards it. Then helping children to assume leadership, engage them in positive interest. Education and academic motivation is something we need to encourage. Spirituality, seeking support, active coping. So all those things is possible for us to work on these protective factors. If you look in terms of familial factors, so let us try to build close relationship with at least one parent or an adult. Supportive parent-child interaction, disclosure and appropriate responses is something we may have to practice not only in our families but also in our society or in our community. We may have to talk about this. Then having supportive relationship outside the family, disclosure and appropriate responses is something we need to develop. When child talk about disclosure about the pain what the child has undergone, it is responsibility of adult to provide supportive intervention. So if you look in terms of what would be the long-term impact of child sexual abuse, so I did talk about the trauma which the child is going to undergo and the scars which are going to remain with the child for a longer period of time. It can be in terms of pattern of sexual behavior. Again, it can be two extreme lifestyles. One can be social and sexual withdrawal or promiscuous, self-destructive behavior. So we can see the two sides we can see in children. Then sexual orientation and preferences. Again, high percentage of boy indicates they tend to become homosexuals. Then history of sexual abuse behind such preferences, and preferences has been part of healing. So child may continue to such behavior as part of healing. Sexual arousal, response and satisfaction. Sexually abused tend to experience more sexual problems. In terms of social consequences, if you look at it, many runaway children are not running towards something, but rather running away from something. That we need to understand. A home life in which they are subject to abuse, particularly sexual abuse, so they would try to run away from something, we need to understand that part. Then teenage pregnancy, female victims of child sexual abuse often are increased risk of pregnancy. If you look in terms of the drug abuse, so it provides psychological escape for them, so they tend to get into using substances, serves as a form of self-medication and as a form of self-enhancement because their self-esteem have been hurt and it has been lowered down. a reduced feeling of isolation and loneliness, they would find answer through substances. If you look in terms of the violence, tomorrow's perpetrators of other crimes of violence, if they survive, and relationship between violence and experience of abuse, again, lot of studies have undergone. So where children who are exposed to more violence, they also tend to experience more abuse also. So just to summarize, so long-term problems, it can be in the form of behavior, it can be in the form of social, psychological or mental health, and sexual. So children do have lot of problems in terms of long-term, which we need to recognize. Now if you look in terms of scope for psychosocial intervention, child sexual abuse itself is a very sensitive issue. So work is not just restricted with the child, but involvement of multiple stakeholders is the requirement. Especially family is a very crucial point. Many a time we all work towards the victim leaving the family. Family also undergo a lot of emotional turmoil which need to be identified and supported. So along with clinical medical intervention, a well-planned psychosocial care plan or intervention is equally important, and this is required for a longer period of time for the children, and we need to evolve at that system so that the children can be supported. Right now we don't have such child-friendly system available within our community. So creating a child-friendly environment is a need of a day. So we all need to work, because we all are in the civil society, we all have responsibility in terms of creating such environment. Now what interventions can be planned out? Is something facing memories is hard, but encourage child to face it and talk about it. Correct negative thoughts, shame, guilt, etc. Continue meeting child for a longer period of time. As early as possible, normalize the child's routine. If the child is going to school, so normalize and try to send the child back to school. Relaxation training is something we need to teach children. Talk about pleasant imagery, reassuring self-statement, recognizing triggers and reminders. So environmental support is something we all need to work towards it. If you look in terms of coping skill training, it is good to share feeling again and again, not with everyone, it should be only one particular person. It is okay to cry. Sometimes child feels confused while talking about abuse, but it is okay, let them be confused. The more they talk about abuse, it gets more easier to deal with it. So encourage children to talk about their abuse. What the areas we need to focus for healing is towards confusion to clarity is something we should aim at. It is possible through therapeutic intervention to make them clear about their state of situation. Then self-estrangement to self-awareness. Then poor survivor skills to good coping. Everyone have some sort of coping skills. Let us identify what we have, what are positive, what are negative coping skills within us, and let us encourage good coping skills so that the child will be able to come out of the trauma situation. So entrapment to empowerment. So we need to empower children to talk about their abuse. Then negative self-image to self-acceptance. So all this is possible when we continuously provide support to these children. So intervention is not only with children, but also we need to do with parents, and the legal support is required in order to bring in these changes. Here I am going to just talk about the mental health team. So we do have psychiatrists, psychologists and psychiatric social workers in the mental health team, where each one have their own roles to play. Psychiatrists predominantly provide medical intervention, whereas psychologists predominantly provide clinical assessment and clinical intervention. And psychiatric social workers, if you look at it, they provide comprehensive care in terms of assessment, intervention, networking, empowering families and child, advocacy for child-friendly environment, family and community intervention, and much more they will be able to do. So we need to identify who are the social workers or psychiatric social workers who are available within our reach, so that their services can be used in providing intervention or support for these children. So there are some prevention strategies which we need to follow. Educate about values in the families, outside, strengthen parenting, facilitate friendship and mutual support, respond to family crisis, link families to service and opportunities, further children social and emotional development need to be done, observe and respond to early warning signs of abuse or neglect. So current practices, what we have is that child and family are seen as separate entities. We are not seeing them as together. So there is some scope for us to improvise our services. And more priority for legal justice than all inclusive psychosocial care to the child. Family members not getting as much support as the child for the smooth reintegration of child into the family. So all these are the areas where we can work on. So the way forward, what I'm looking for is from the individual, family and community level, we do have certain activities which we need to do. One can be life skill training, sex education, self-protection training, then training parents, empowerment of parents, sensitization and awareness program. Here I am particularly looking at the legal system. The lessons what we learnt in mental health, when the legal system takes active role and give guidance to the state government, services have been brought back at the district level and at the taluk level. The similar way, if we can look at it, if the legal system takes active role and give guidance to the state government to introduce all these activities as part of preventive mechanisms, which can be easily implementable at the state level, taluk level or at the district level. So that is something I look forward from the legal system. The role of magistrate in recording statement, again I want to stress few points here. So allowing child development or a mental health professional to assist the statement recording in spaces where the children are not comfortable, particularly outside the court if it is required, magistrates need to recognize that and allow that statements to be recorded outside the court. Using play and other creative methods can also help in getting narratives from the children. Again, the mental health professionals are trained in terms of using such mediums. So we need to recognize that and allow that mediums to be adopted. Permitting of use of an audiovisual recording of child statement, especially when it is recorded by mental health professional in spaces other than the court, that need to be allowed. Then ask for additional or specialized assistance by the way of interpreter, translators, sign language experts, special educators for children with disability. Then allowing family caregivers, therapists, counselors to accompany the child and remain with the child during the magistrate statement recording, because child may not feel very comfortable talking to a third person. So known person within the with the child will help the child to talk about their problems. So there are certain things which you may have to do. Let us not hurrying the child to talk. So allow child to take time in terms of talking about their problems. Persuading the child to provide information through like giving sweets, toys, chocolates may not be a good idea. Asking children to enact what happened, again it's not a good idea. Probing for details of how the child felt at the time of abuse. Touching the child unnecessarily, something which need to be avoided. Again, I would request the judicial members to ensure that an order to the state is being passed so that all these things can be implemented easily, like relief and compensation, legal aid can be given, send copies within 24 hours. These are some of the mandates which is being given as per the Act. But only thing now, if we can have more involvement, it is possible for the state government to issue special orders and see to that it is getting implemented. So I would like to conclude my presentation here by three statements here. Effect of sexual abuse range from mild to severe, and it will not be same with every child. So every child it can be a different, and it is need to recognize such impact and also provide support, which is the responsibility of a civil society. And we also need to recognize the importance of caregivers in the treatment. So caregivers do undergo a lot of emotional turmoil. So services also need to be provided for the caregivers. And something CBT approach we have found is being very effective while we are working with children. So we need to talk into children, help them in terms of refining their cognitions and thinking process, which would help them to empower themselves and come out of that low self-esteem, and who can experience dignified life, and that then they can be able to take care of themselves. That is something we may have to follow. So thank you again for giving me this opportunity to share my thoughts. So I'll be happy to receive any questions in case if any audience would have. Thank you, sir.
Thank you so much, Dr. Janardana.
We have had a wonderful session with the experts, beginning with Mr. Ananta Kumar Asthana, advocate and also a child rights lawyer, member of the Bar Council, on various aspects of the various provisions of law as provided under the rules and act, like describing the procedures and responsibilities of the various stakeholders. And we have also a wonderful presentation from Ms. Swagata Raha, giving a detailed analysis, in fact a post-mortem of the various judgments, and trying to find out what actually transpired in these cases. And we also had a very enlightening speech from Dr. Jagadish Reddy on very important aspect of the whole entire legal system. That's a medical test. It is very critical and crucial for the success of an investigation or a trial. And of course, we had a very wonderful session also just now. Dr. Janardhan has given on the mental and health and the psychosocial counseling. It's a very important component. In fact, this is one area which perhaps many of the stakeholders are not giving too much of importance, because how to understand the problem of the child, how to elicit the proper information from the child and the witnesses, and how to deal with this. These are all relating to the human psychology, human behavior. We as judges and lawyers, we are not really trained in this area, but then we have to deal. We are the primary stakeholders. How do we deal with that? Therefore, it is a wonderful session. What I will say, without going much into detail of what has been already spoken, we have already heard. It will be, though the time is already beyond that, but I thought that it would be better to have a discussion till 1 o'clock. Maybe we can continue also, because the next session is the presentation from the states. We have still time in the second half. We'll pass, because the last session is kind of closing session. We can sacrifice in that, because what is important is to understand and interact, especially when the experts are present here. I would request participants to open up. Please don't think that if I ask this question, people may think, oh, maybe others may think, I don't know why I'm asking this question. No, I do not know anything about this POCSO. I never did. I never practiced in POCSO, never decided any case in trial. You are much better, knowledgeable. So I with this confessional statement that I don't know anything about POCSO, please open up. Because there are many issues, I know. You know many things also, but still there may be certain areas perhaps you would like to get clarified. And what is the better scope than all the experts are here, both physically and online. So I'll be very happy. Any judges, lawyers, and investigators, prosecutors are here, and all support system. If anything, kindly do not hesitate. But that's why we are all sitting here. Your question also will enlighten us also.
Good afternoon, sir.
Thank you. Yes, please.
Sir, I am CBO Srirang, Khurosri Pathak.
Yes, please.
I have a question regarding the presentation made by Raha Madam.
Yes.
Regarding romantic cases. Ma'am, we recently have come across one case where one girl, she ran away with her own maternal uncle, and she married with him, and she is now 7 months pregnant, and her mother lodged a complaint, so the boy is arrested, and the girl is now in the CCA for temporary shelter, and she is not ready to surrender the baby. She said that she will deliver the baby and keep the baby. And as the relation is not acceptable for the society is not ready to accept her back. So for her long-term rehabilitation, ma'am, we are facing problems. So we need your guidance, ma'am, regarding this.
Thank you so much, ma'am, for your question. And what you have shared is indeed that there are several dimensions to this. One is, of course, the nature of the relationship. This is a maternal uncle and a niece. And in certain parts of the country, this relationship is accepted. Like I'm located in the south. It is an acceptable relationship for a girl to marry her uncle. But I don't know the area that you are referring to, whether this is an acceptable relationship or not.
Not acceptable in our
Right. So it is not acceptable. That is one. And second, is there any possibility of coercion or grooming in this situation? So that is also another dimension that one has to think of. With respect to her not wishing to surrender the child, that is entirely her decision. And that is something we all have to respect and enable. So what aspects of the JJ Act can we use to support her in the upbringing of this child? Can sponsorship be considered after she, as long as she's within the state care system, her needs are going to be provided for as well as that of the child. But once she exits the system, can there be sponsorship that is ordered by the Child Welfare Committee? Can we also look at aftercare? And what would that entail? The bigger problem, I think, which the law doesn't have any solution for, is how society is going to accept her. That is a larger issue, which law is very limiting. But at least if we are able to operationalize what support is available under the JJ system for this girl, we will be able to hopefully offer her some support as she navigates through this situation.
Ma'am, actually, in a CCI, she is residing in CCI now. But after delivery, ma'am, where the child will stay and where the mother will stay. Because 5-year child cannot stay in a CCI. And we cannot separate the mother and the child. So,
yes, ma'am, that is the core principle here. You have to look at the mother. She might be a child, she has another baby, but the baby is of the child in need of care and protection. We cannot separate them.
If I can put a few words here. I came across two cases. One was in Arunachal in a care home. I referred it yesterday itself. The child mother and the baby both were very happy, it seems. They accepted whatever has happened. Other consequences will definitely follow. But the question is regarding what will happen to the child. Another matter, I am dealing on the judicial side. Here also there is a child mother. The child mother is staying with her father, who is economically not very well off, cannot provide for the child. What we are trying is whether the state can provide adequate education and the whatever is to be attended to the child to provide for that. And possibly
that is why the DCPUs and all this will come into play.
One way of looking at
yes, that is what the role of the state becomes very important. I mentioned also, see how this regime is not about mere prosecution or investigation. It is also to provide support to the victim, which is essentially the role of the state.
And in fact, the state was very cooperative.
Yes.
And state is ready to undertake the education of this child up to the point it is required.
That's wonderful. Yes. Any other question from? Yes, please.
So, may I? Maybe related to that romantic thing. In Mizoram, they elope who are underage. And they stay in the family of the boy's house, though not ceremonized. But when the census is done, they were registered as couple. This makes the image of Mizoram to be like having child very high in child marriage. So what to do with that? Because like a high school student who are like 16 years old, 17 years old, they elope and they stay
in the boys' family. And when the census is done, the primary school teacher or the census who are getting the information, they reported it as a couple. So that's the problem. That's why Mizoram is looking as high in child marriage. What can be done on that?
Let me just add to that. I'm from Mizoram too. At least the case is not registered. Okay. So I have many cases in my court. Madam Vidya calls it the last time we had a session, Romeo and Juliet cases. So we have so many Romeo and Juliet cases. And it's very difficult to write a judgment because, and ma'am had told us the reasons, many reasons. And one of the reasons that ma'am didn't mention is victim compensation. Victim compensation.
Yes. I request both Dr. Janardhan and as well as Swagata to respond to this one by one, because
like
we'll take maximum advantage of the presence of...
Yes. To put someone behind 20, in bars 20 years, knowing that, they have not done anything wrong. And when the guy comes, in some cases, when the guy comes to the court, the girl comes running, hugging him, knowing that they were in love. It's just the parents who are not allowing them. So and it's very clear some of them are pregnant. And it is clear that it is their child. So that means the penetration is there. And we have to convict them anyway. So it's very difficult. I feel very guilty about it. So can the law be amended or something can come out of this session? I'm just asking.
Yes.
One thing we all need to teach our young children, it's okay to get attracted, but not okay to act upon attraction. So let us recognize getting attracted to opposite sex is part of normal development. Let us teach them what are the boundaries they may have to practice. Talk about boundaries to children. And if you start restricting them, they are going to counter-react on our restrictions. So which is not going to solve the problem. So let us try to normalize that it is that age they are going to get attracted to opposite sex. So let us only look in terms of attraction, not to give the color of love. Because in Indian culture, any love should lead to a marriage. So there is nothing like we don't have a dating culture. It's not our culture. So anything love means end should be a marriage. So there I think we need to have a break. So we have a lot of scope to work in the schools where we can talk about romantic relationship. So what are the things they may have to keep in mind? Getting attraction is something normal. So let us normalize it so that we will not get into all this problem. Again, a child marriage, if it is practiced in the community, we do have certain legislations in the country which would prevent child marriages. But again, it's going to be very difficult in terms of implementing at the areas where the roots are very strong. Only through education and creating awareness, it is possible for us to work on it. Even if we are reducing 5%, it's a great achievement. So right now, maybe over a period of time, it is possible for us to change the mindset of people.
I have a little difference of opinion with Dr. Janardhan. Of course, he's a specialist here. But the reading that I have done in terms of adolescent development and what I think if we also go back to our own adolescent period, we might just recall having crushes and some of us may have even acted on it. So at least what science is telling us is that it is extremely normal. There are hormonal changes that are happening during the period of adolescence, and to act on it is also normal. The question we have to ask, because this is predominantly an audience that is, within the legal system, is that can the response to it be criminal in nature? We may not like it. We may not think that it is appropriate for them to be having these relationships or engaging in sexual behavior, but does it merit 20 years of imprisonment? Does it merit them being sent to an observation home or a children's home? What is the message that we are giving them? That you are acting on something that is normal, but yes, we are going to punish you for it, and it is going to be punishment that is a minimum of 20 years. So I think we have to really ask ourselves, is this how we want to respond to adolescent sexuality? And so what you asked in terms of child marriage, if we see in India, the rate of child marriage has significantly dropped. What it was 10 years back and what it is today, there has been a significant drop. And I'm assuming even in Mizoram, there might have been a drop from 10 years to now. But the question is, has the law contributed to it, or is it socio-economic measures? Is it access to education and opportunity that has led to a drop in child marriage? So I think if we make education available to all children up to the age of 18, right now RT is only till age of 14. If we offer, social security schemes that are aimed at empowering girls and to enable them to access opportunities, even if they don't want to study, are there vocational training programs? So I think the answer cannot be in law, but we have to look at what are the additional measures that need to be taken at a governmental level to address the problem of early marriage. Because what we are seeing now in India is a problem of early marriage. That has really increased. And so, ma'am, what you said about pregnancy.
My main question is that although we are teaching them all the education which sir has said, but still it has happened, and they stay together, though it is not ceremonized. But when the census came, it is registered as a couple. So is there any possibility that when the census is done, they are not married? Can they be registered as not married? There is no certificate, there is no ceremony, it is not ceremonized also, but when they go and collect the information and they put it as a couple.
See, that's the whole problem with enumeration. We have all voter lays, you are only 50 years, they show you 27, then you have 15 years, 60 years, you are shown as a female also. All things happen, therefore these are area the government has to, of course, these are certain areas where we have little much to say, except that the enumerators who go there they just sit in the office and ask, just fill in the forms. They have to really go and interact with individuals. Of course, these are areas where we need to improve upon. Yeah, that's true. Yes. So that everybody can hear, because in the corner, yes, please. Order that wireless, yes.
So I have a question, actually.
No, just because he will continue, yes. Yes, please.
Mic is not working, I guess.
Actually, during my tenure in Tamilpur district, it was probably 1 year back, there was a case, I'll just refer to that case. One Nepali minor girl, but she was well-built, she looked as a grown-up girl actually. She was 16 years old. So that girl eloped with a Muslim guy. There was necessarily, it was a very lot of complaints and lot of pressures were there from the communities, and they fled to Bangalore, sir. Then although we knew that it was an elopement case, since the girl was of minor age, we sent our team by doing all the mobile forensic analysis and everything. We sent one team and we recovered both the minor girl and the accused. The accused was major, of course, accused from Bangalore. The team stayed in Bangalore for 7-8 days. They went twice actually. First time they meet me. Then after that they came. We have the girl. She refused to get medically examined, and after that in her 164 statement also, she said that there is no physical relationship. So after that, since the girl was minor and consent of elopement that does not matter, that's why we have forwarded the accused to judicial custody, sir. And the girl, she directly refused to go with her parents, saying that they even physically or mentally harassed the girl, which was, I think it was not true. And after that, the girl was produced before CWC and she was kept in a children's home, sir. the Baksha, this DCP unit, CWC and the child care unit, everybody was involved in this process. And after, sir, one month, the girl again fled away from that children's home and she came to the boy's house. The boy was in judicial custody and she used to stay in that house. So in such a scenario, what should be the course of action? Again, there is a lot of pressure from this family, from the girl's family, that we should rescue that victim girl. Again, she has been victimized. So this is one case, sir.
Just because we are sitting, three of us here, doesn't mean that we'll take all the opportunity to answer. There may be some other person who thinks who can give, will be happy to hear him also.
I will just not.
Yes.
It's not a question. This is a suggestion.
No, but from what the police, yeah, he just wants, because what to do with this kind of situation? I mean, somebody, because these are we are dealing with human problem, we are not sitting in, doing some mathematics and, chemistries or some, it's human problem, you could come up with better, if you have some ideas, judges are here, prosecutors are there, the NGOs are there, please come up. I mean, this is what we want to learn also.
I can just answer this particular question. I'll keep it short and, on that point. There has been a full bench judgment of the Delhi High Court in Lajja Devi on the context of child marriage and whether the custody of the girl can be given to the husband or the husband's family. Because the law is confusing. The law is saying child marriage is an offense. POCSO, if there is any element of sex, that is an offense, then how do you send her back to that house, right? But what the Delhi High Court said is you have to go with the best interest principle. Where does the best interest of this girl lie? If she is saying that her, her family is posing a threat to her, and in this case that you described, it is an interfaith case, right? She's a Hindu girl, is a Muslim boy. And we have seen cases that this has sometimes transcended into violence against the girl if she is sent back home. So based on that principle, and several other high courts have also said this, the CWC can decide whether the husband's family is a fit person, if the mother-in-law can be a fit person in whose custody this girl can be given. Because keeping her in a children's home is no answer. It's not improving her life in any way. The accused is already in judicial custody. So if we apply the principle of best interest and see whether in this, it has to be a case-to-case based approach. It cannot be that in all cases this is the answer. But in this situation, one can explore if this is a possibility.
Yeah. Actually, the presentation and the topic with the points which were discussed from me, those points are extremely relevant from the investigator, the policing perspective. One more case, ma'am. Actually, you have mentioned this thing. Actually, they are already made this. I was supervising one case. The girl, she was 13 or 14 years old. She eloped with a matured guy, and after that, she was medically examined. The medical report also came positive. She has given her 164 statement, and she told that, okay, I was raped. In her statement, she said that. But after that, there was an agreement between the family and the society, and the girl got married with that guy. And after that, now the case has been pending for the last 12 years, ma'am. Again, my question to the August forum, that in such scenarios, what should you do? Because the case remains pending. If we go to arrest that person, they are having 3 children. One of the children is going to class 3.
Honorable Judge, the High Court as well as from the, it is a, please.
Sir,
yes.
A very good afternoon. I am Dr. Oli Goswami and I am from the Department of Forensic Medicine, Gauhati Medical College. And I look after all the sex crime cases from Kamrup Metro and Kamrup Urban. So there are some few fundamental problems we have at the ground level, which were actually not highlighted, I think, adequately in the discussion that was telecasted from Bangalore, because these are our ground level problems and we know it. And having worked, and I work in GMCH under an umbrella cover of the police surgeon Kamrup and the superintendent GMCH, the principal GMCH, where I have problems. So you please think about those lady doctors who are working at the periphery with no umbrella cover, and how much problems they must be facing at their ends. So, sir, I'd just like to begin. I'd just like to highlight a few points. I may take a few minutes if you allow me, because maybe I'll never get a chance again. Firstly, sir, nowadays, whenever the forwarding letter comes, some of the forwarding letters, they come with the GDE number, General Diary Entry numbers. And when we ask for the case numbers, because I know with my limited knowledge that the cases have to be registered and a case number has to be provided in the sex crime cases, be it POCSO or the other cases. But in some cases, the case numbers are never provided, and when we ask for the case numbers, we get a very bad reply from the IO concerned.
But what is the problem if you continue with a GD number that itself also?
No, we continue. We do the examination and everything.
Then I don't think we are at this stage. There is no point insisting upon the FIR number, because that is a legal issue that will be taken care of. What is important is that investigation can be also initiated on the basis of GD. What you are supposed to do is to gather the evidence and also give therapeutic treatment to the victim. You do that, the law will take care of it. Why insist and have an argument with the police why you are not giving the case? Yes, please. Yes, please.
The second problem that we face is regarding the consent. The consent, sometimes it is a preformed consent. Sometimes the victims or the survivors, if I may say so, are sent not once, but twice or thrice for examination. Sometimes it happens so that they do it under force, and the problems inside the rooms we have to face. Because sometimes they come with just a complaint that we have been touched here, immodestly here and there, and after doing a thorough examination, we get to know that they had been subjected to some sort of penetration or insertion in the past. But when we ask them that is there any history, because we have to write a history, sir. So to correlate, sometimes with just if we ask that is there any history of so and so, that leads to a very bad outcome inside the room. And since it is we are alone inside the room, it's a very difficult situation for us, because twice two girls told me that if you write the truth, then I'll commit suicide. And then one girl...
Correct. This is in fact, if you have, in course of discussion also it came up, you can't ask questions. I'm not talking of the doctors. In the court, we can't ask questions about your past history. So you have to be very careful in asking. That's what the psychology, that you are not doing merely, you're conducting examination as a clinical doctor. You have to take the role of a child psychologist also. You don't have to ask so directly because that's what I would, in fact, in this kind of while medical examination is going on, just like while the court examines, takes a witness, evidence of the child witness, where you use these educators and interpreters, why can't you also use the service of these child psychologists to help you also? We understand, we appreciate, that is what we can also think about, how to deal with these issues when children are produced before you for actual examination, how to make them cooperate with you.
One more, sir, regarding the ossification status, we have a lot has been talked about the ossification status. Sometimes we do on our own also the ossification status. We feel that the girl will be above 18, so we do on our own. But sometimes if we advise also, it is not done. And thirdly, one more thing I'd like to bring to the notice of the esteemed house, that the investigations, the skygrams that are provided to us, now with the increase in technology, the skygrams that are provided to us are digital skygrams. So how far is it actually advisable to use digital skygrams? Because sometimes the skygrams don't match, because digital skygrams are computer-based. There is always some chance, because it might not be intentional, or it might not be of any bad way that a person wants to do it, but sometimes there might be some mixing of the skygrams regarding the digital skygrams. So if something can be done about the conventional skygrams, it would be better, sir. And thirdly, about the old injuries that we have been talked about again and again. So reporting of the old injuries in a child of 5 years, if the child has been, there are old injuries presented over the hymen in a child, which are maybe old incomplete tears or old complete tears. It is advisable to mention that in our final report, because if we don't bring it to the notice of the court, honorable court, that the child has been abused or has been repeatedly abused in the past and that abuse has still been going on, will the girl be safe only mentioning about the recent injuries?
I think as far as the doctors are concerned, you don't have to go to the legal evidence or admissibility or what would be the legal repercussion and consequences. Perhaps, if I'm not mistaken, your duty will be just to reflect what is there on the body. What legal consequences will flow out of it, let it be decided by the court. I think your duty would be perhaps to reflect truly all new, whatever. If you think, according to you, what you feel is correct, it is for the other investigators and ultimately to decide. I mean, this is, yes, please.
And sir, lastly.
Okay. I'm told that, okay, please, if you have something more, yes, please.
Yes, sir,
Please, without any hesitation, we will continue this session till 1:30 also. In fact, if necessary, we can go on after lunch also, because this is what is important. We have been listening throughout the year, sessions, we have been, I don't know how many sessions we have been listening to, so many. But this interaction is much more productive. I mean, not without, So please.
Yes, sir. Lastly, our duty is till 4 o'clock. My duty is till 4 o'clock in the for the examination. So after 4 o'clock, if any case comes, if the case involves law and order problem, then obviously I am called to examine the case. So POCSO cases I am calling. But if suppose it doesn't involve a law and order problem and the child can come the next day, then a male doctor of our department comes. He doesn't take the slide. He doesn't do anything. But the vaginal smears are taken by the GNM or whoever is there, and the child comes again the next day. So, sir, if in the medical colleges of Assam at least, a one-stop center can be established where the child don't have to come again and again. The child again comes the next day. Again, the child have to run to the radiology department if required.
Yes.
So those are the
Thank you very much.
Thank you so much, sir.
Just a minute. Thank you very much. Because what I would suggest before I'm happy that Dr. Jagdish Reddy also online. He would like to respond, but I request before I request Jagdish Reddy to respond, I just want to make a suggestion to you, madam. In fact, perhaps from our side, we will try to make a team and interact with the doctors. The kind of problems, as you mentioned, you face, how to deal with that, because that will be a very good from our sharing our knowledge and trying to, because ultimate purpose is to find the truth of the case. It's not really to convict and accuse or something like that. Our legal system is to find the truth. He may be falsely accused. We don't know. That is for the legal, ultimately. So we will request that if you can get hold of these kind of queries, the kind of the difficulties you face on the ground level, so if you can share with us as a committee, we'll find out, prepare a team from our side, interact with you, and make a whole idea. Then you'll be able to discharge your duty in a much better atmosphere. I'll request Dr. Jagadish, who is online, he perhaps would like to respond to some of your queries. Thank you, Please, Dr. Jagannath Reddy. There's a problem? Yes.
Our colleague's question. We all as doctors should first look at how these victims of sexual violence would reach our hospitals on their own, because Supreme Court way back in 2000 only recognized that they have a right to come on their own. And now the laws also, Section 27 as well as 357, insist that there is no need for a police requisition or a magistrate order. See, we all have to raise that situation where people walk into our hospitals and we initiate the mandatory reporting rather than we try to look at the procedural issues of whether I get a request after a crime registration or a case diary entry. The second issue was regarding the extent of examination and certain times what's the history given. The law is very clear, and I don't think as doctors we need to get beyond that. See, at that material point of time, what is the consent I get? So the informed consent what I get. Based on that itself, I need to do the examination. At that material point of time, I don't want any doctor to step into the shoe of an investigating authority. You are a therapeutic carer. Along with your therapeutic care, you are assisting the judicial system or the criminal investigation system. Our primary role is therapeutic care. I don't want to step beyond that. So if during the course of your history given and your examination, if there is inconsistency, I think there is nothing which prevents you. The history given is this, and on examination, I find, or on gross examination, you find if there is inconsistency. They say that there is nothing being touched, and you find there are injuries which would go towards it, or there are lesions which goes towards it, or stains which goes towards it. You always document in your report. See, we are no system is going to put you on the wrong side, saying that why you are not gone through the history. See, you have looked at the history, and based on your examination, if you find there is inconsistency, you have documented those examination findings. Regarding the next point of your age estimation issue, we have to look out. Section 94 of the JJ Act from 2015 is in force. Now there is emphasis given on documentary proof of age. It's not compulsory age estimation in every case. Only when the CWC or the JJ board finds it that the documentary proof is not sufficient or not clear, so then they would refer, and there are enough, even the model guidelines also point out towards a panel of doctors doing it. The question of you raising a doubt saying that if I am using a digital X-ray, the identity of the person could be masked. There are enough safeguards because almost all the hospitals, majority of the hospitals in this country are now using the digital platform for radiography, and there are enough safeguards for if you are doubting, saying that somebody would try to change it in your own system. So I think you would be viewing those digital X-rays within either an intranet of your hospital. So that means if that safety you have taken care that nobody can have access to tamper with those radiographs or change the identity. See, we are looking at only one point of view. So that means if your hospital is using a digital X-ray for all the therapeutic care, so the same thing yardstick applies over there. So you have to strengthen the system wherein there are no person who is going to falsify. Because for the want of this issue, going back retrograde in having a film-based radiographs, I don't think it works good because economically also a digital X-ray would be a nominal amount compared to the old traditional X-ray. The other issue which you raised regarding the old injuries, whether I should document. See, whenever you find a case of repetitive sexual abuse, whether it's an adult or a child, even the ministry guidelines very clearly point out, as a routine you are not documenting the old injuries, but in those cases where you have a repetitive sexual abuse, so then definitely you have to document the old injuries, because that is how you are going to provide evidence for proving the repetitive abuse. So, but what has to be meant in remembered, all cases in front of us are not repetitive abuse, but wherever it is a repetitive abuse, definitely you have to document the old injuries. Regarding the last issue of repeated examination, all the stakeholders have to understand we all are working in the best interest of the child, and this 10 years down the line, though we are looking at several challenges, we are looking at, we should not forget that we have moved many steps forward, and there are so many innovative things, new things, strengthening things which have happened all across. It is only if you feel saying that the duty doctor at that time is sending away. So you have to work out a mechanism within your hospital wherein you have round the clock a person available to carry out. See, no systems decisions for the best interest of the system should not hamper in the best interest of the child or the victim in front of us. We all have to work out for that, and when the law recognizes that we all are working towards safeguarding the best interest of the child, so the hospital also has to make those SOPs. So I agree the pressure what you have as an in charge of the OSC or as an in charge of looking into all this. So please involve your higher administrators. Justice Koteshwar Singh was kind enough saying that you please list out all those things, and maybe from the Juvenile Justice Committee, if you are finding a difficulty to address with your administrators, the Juvenile Justice Committee could iron out those issues, and all of us could work towards the best interest of the child. So thank you very much.
There's some judge who wanted to, yes, you wanted to say something, yes.
Good afternoon, Lordship and our esteemed resource persons.
Mike, this note on. Yes, there's another mic coming, yes, behind you.
Good afternoon, Lordships and our esteemed resource persons. I am Ipsita Bothakur, Special Judge POCSO Naga. Since one of the segments of this session is the romantic cases, one of the problems that we are confronted with is that we are in doubt whether all the so-called romantic cases are actually romantic cases. Like what happens, the survivors, we issue summons to the survivors regularly, like those summons are served by police. And then they come to the court, and the special public prosecutor many a times is totally unaware that the victim or so-called survivor has reached the court. Before reaching the court, she reaches the bar and then shells out a version that she had a romantic relationship with the accused. But when we go through the statements recorded under section 164 CRPC, she has a different story to tell. And then subsequently, this romantic angle is lent, and the court is also helpless because when the victim or the survivor herself says that I was into a love relationship, and in cross-examination, defense also has one stereotypical question these days that, why did you make the statement under 164 CRPC? She says, I was tutored by the villagers. And the story is finished. So I have one suggestion, if it is feasible, that instead of the summons being served by police, if the Child Welfare Committee can be saddled with the responsibility of bringing the victims or the survivors from their homes, bringing them directly to the court with the public prosecutor, and then taken to the children's room, and then her evidence be recorded. If that is possible, Lordship, perhaps the clearer picture would emerge.
Who?
Ananta Asthana.
Acha.
He wants to come in.
This Ananta, okay. Okay, I think Ananta, child rights lawyer, would like to step in, perhaps. Yes, you are most welcome. You would like to respond to this question, or you want to generally? Mr. Ananta Asthana? Is there? No.
Sir, I very much here, but I
Yes.
missed the mission because of the loss of the bandwidth. So
Okay.
my apologies.
No.
My Lord, I may just, maybe I'll help answering the query. I'll also like to add something. My Lord, if I'm allowed.
Yes, please.
I am presently working as a secretary, District Legal Service Secretary in Kamrup Metro. In fact, Madam Raha had, in her presentation, talked about a 5.9% conviction rate. Ma'am, you all had a research on romantic cases. Ma'am, Ipshita just presented or talked about some cases, romantic cases, which actually are not romantic cases, but turns into romantic cases, so-called romantic cases. I have experiences where actual cases are settled or for 50,000, because we as DLSAs, also become support persons in most of the districts. Barring maybe Kamrup, where we have actually a support-based organization. In other districts in Assam, there is no such support-based organizations. So we have first-hand experiences. My lord, in Bongaigaon, I have an experience where a physically, or I would say a special child, was molested, sexually harassed, and then when we went up and we talked, the parent said ki we have been offered by the accused a lakh rupees. So what we do, we try to counsel, see, we are looking after the compensation, we'll offer you, you'll get much more. The victim scheme provides. But I think we had Dr. Janardhan also talking about a mental health. The timely non-disbursement of the victim compensation results in unromantic cases turning into romantic cases. Because then the accused gets a chance to offer money and get them settled. So this is also one condition which I found the same condition in Gauhati also. In fact, I had to counsel, I said, we'll offer, but we cannot offer money because we don't have that fund presently. But once it is delayed, so ultimately the accused side gets a chance to settle through monetary. So probably the timely disbursement of the interim compensation is a huge factor in not only rehabilitation, and also bringing the levels of conviction rate higher.
Yes, Mr. Ananta would like to respond to some of the... Okay, you want to add to it? Okay.
Hi, I'm so sorry for delaying the process, but I just wanted to speak along the lines. I'm from Studio Nirima and we work with UNICEF Assam as knowledge partners. And in our analysis, we've noticed that in this context of the convergence of MTP Act and the POCSO Act, ma'am had mentioned about the age of consent being a factor. So along the lines, I wanted to ask, because we've noticed in our analysis of Assam that when the urban and rural divide comes in, the context completely changes. Because young female children in the context of rural Assam, they are a cycle of deprivation because they come from financially backward households, and eventually they are engaged in either as child laborers or child marriage, forced or by consent. But when it comes to the urban context, a district like Kamrup Metro, the children come from a very different set of privilege. So engaging in any form of consensual or unconsensual engagements in adolescence, I think the context changes. So how do we factor that in when we are talking about bringing down the age of consent? Okay, thank you. I would request Ananto to briefly respond to that. We are aware also that clock is also ticking, and we can continue our session, but then postponing the lunch may create a problem for the body, biological body. So we'll request Ananto to briefly respond, and we can continue subject to the view of the, body. August body feels that, yes, we should continue after session also in this discussion. If the body feels that, then we can do it, because the presentation can be done. Certainly we'll wait for the presentation, but I think this is a very educative, very kind of session which is going on. Before Ananto Asthana responds, yes?
I have a suggestion.
Yes.
The second session that I'm going to chair.
Yes.
Now this topic is touching into this also. So when the two resource persons are present,
yes,
and the other two on the online,
yes,
what we can do is after lunch, these four states can give their presentation, and we can proceed. We can,
okay, fine. We can do that also. What I'm trying to say that this session, this discussion session, can continue whether after immediate after post, because that is okay. Because we can do whatever the House August says, because the House has every authority to change the format.
So we have a flight at 4.
Oh, sorry. Oh, I'm so sorry. Okay, brother, I think the resource persons, they have to, at 4 o'clock, that means they have to leave by 1. Then maybe then in that case, what we can do is we can postpone, we can request everybody to, control your own hunger for another 15 minutes, then lunchtime, and we can break. Then resource persons can go also. Asthana, please respond. Then another 15 minutes we'll proceed. Thereafter we'll break for the lunch. We have to make compromises everywhere in life. Yes.
Technical issue.
Oh, then technical. Achha, in the meantime, perhaps you
I
can
can
respond. Yes. Yes.
I think some of the things that have come up, there are certainly several dimensions of romantic cases, and we also have to be aware that we should not romanticize romantic cases. So I am fully aware of that, and I think data helps us also understand the extent of the cases that you refer to, ma'am. From Assam itself, we found there was 7% of cases within our pool which had an aggravating factor, which had a factor of violence, which had a factor of the relationship being one of authority. But again, when you look at the absolute numbers, you find that this is a minority. Majority are cases where it is not exploitative. There are a few cases which are exploitative, and yes, the system should definitely respond to the cases. Your suggestion of CWC being that authority, unfortunately, CWCs have a very clear mandate in law, and they are also suffering from lack of infrastructure and resources. So if they have to take up the mantle of now ensuring giving of summons, then that entire child protection system may collapse. They may not be able to even do the basic minimum that they are supposed to. But the suggestion that you said, and I think what Sir also said, there is a need for a support system right from the time that the case is registered. So if that support system kicks in, that support person, it may be a PLV in a DLSA, it may be a non-governmental organization or the DCPU. That support system has to ensure timely access to compensation. Meeting with the public prosecutor before and not on the day just before the child is going up to give evidence. Unfortunately, we don't have that. And this is the problem that you are describing is what we see in actual cases of exploitation. You refer to could be a actual case which is now taking the shape of a romantic case. But this is a problem we see across the board in real cases where there is no support, and by that time the accused has bought the family and they're turning. So we have to solve the problem from a larger systemic support point of view. And also the point that you raised about the urban and rural divide. Now, when it comes to the age of consent, what we see is that children from our family, like my son, is not going to be hopefully implicated in a POCSO case because we come from families where there is some cultural acceptance that these relationships. Can you hear me now? Yeah, sorry. I said that let us look at the class of people who are coming into the criminal justice system in a romantic case. It's not my son. It's not my friend's daughter. Because there is some cultural acceptance in our families that our children will interact with, children and may have romantic relationships, and that is acceptable to us. It is when the family is completely opposed to it. And it is also not that the family is saying, please study and don't do this. It's also cases where the family is saying, no, we will arrange your marriage with somebody else. And that is when that girl is running away and getting married. So when it comes to the urban-rural divide, we have seen, at least when we look at data in this form, that even if you are located within an urban setting, there is also the urban poor. There are also dynamics of caste, class, religion that come into play, which then brings these cases into the system. So when we're looking at an age of consent, it cannot be exceedingly low. We are not saying that bring it down to 12. It has to be at a place which is reasonably high, but not as high as 18, because that's the problem that we are faced with now. We are not recognizing that during adolescence there is these relationships are normal. So what would be that ideal? And at the same time, how do we ensure that if you are 16, you are, say, in a relationship, but the sex is non-consensual, you still have protection under POCSO. So that's, I think, as legal minds, we have to put our brain together to see what that drafting would look like, so that as far as possible, everyone enjoys protection under POCSO, but at the same time, you are not victimized for engaging in something that is developmentally normal. I have one more response to, sir, the additional SP crime, the case that you mentioned about 12 years, the case being pending. I think if the family can be encouraged to approach the High Court under Section 482 to have the matter quashed so that everybody can move on. I mean, that is one way of, proceeding.
I can understand the case is pending for 12 years and charge sheet is not filed only because he has to be arrested. But arrest is not a must. No law says that you have to arrest. You can file charge sheet even without arrest. It is in the law. No law says that there has to be an arrest. arrest is done, because of the necessity of the case investigations. If you file arrest is not necessary, you can file charge sheet. Your case should not be kept pending for 12 years or because of arrest. You file charge sheet, let the court issue summons and take care of the matter. Even recently, the Supreme Court has also said that arrest is not mandatory always.
I have one, because Dr. Janardhan is there. I hope you can hear me. I wanted to say this because while we're talking about romantic relationships and when we are saying, I think we should also kind of inculcate some kind of sensitivity in conversations, because you said it is natural for a guy, guys will like girls, but if you look at it perspective from alternate sexuality, which is hardly spoken about, and the medical legal guidelines clearly speaks about how doctors should deal with children with alternate sexualities. So there is a possibility that a boy can also have a romantic relationship with a boy, and a girl might have with a girl. Transgender child might have with another transgender child or a boy, because the spectrum is huge. So I think these conversations are also necessary, because we get cases wherein boy children come up and they don't want to go to a doctor or a psychiatrist because the psychiatrist or doctor would not understand what the child is going through. So this is one point. Now this reflects in the way how we are institutionalizing children. We have cases where a boy child who probably is a transgender child who identifies as a girl child is put into a child care institution meant for boys and would not want to stay there. And then that same boy child will be transferred to a girls' children's home where the girls are not comfortable of having a boy child there. So these are things that the system should also maybe take into consideration while we are talking about sexual crimes under POCSO Act, because girl children, male children, transgender children, all are victims of child sexual abuse as well.
I think the sexual orientation need to be understood. So again, everyone have right in terms of their own sexual orientation. So which need to be considered. It's not necessarily romantic relationship is between opposite sex. It can be within sex also. With regard to a second comment in terms of a transgender child. So in the state of Karnataka, what we have recently we have opened a home, CCI, for transgender children. So I think more like that from each state government would be an answer for children who are having sexual orientation issues. But we do need to recognize that children can have attraction to same sex also. So the point here, what we need to teach our children is that I too agree with Swagata in terms of the legal provision of 20 years punishment is not the way we need to look at it. See, we need to teach our children, like we did a small study in terms of romantic relationship as part of our PhD degree. What we found in this study is that in Karnataka, this study, almost like we interviewed around 120 children. But what we found was all 120 children were aware about age of marriage. As per legally 18 and 21, they were aware. But they were not aware in terms of the consequences if they have to break this law. What will be the consequences? They were not aware. And other thing what we found was majority of them did not know either caste, which is an important in South India, caste of the person, income of the person, parents, the nativity of that person were not aware. Majority of them did not know about it. This person used to come in a car, so they used to think that this car belongs to him. They were not aware even the income of this person. So again we can go with the thing that love is blind, where it is not required for us to look into all these matters. But also it is the life of the person also. Person need to make a judicious decision. If I am getting into any romantic relationship, so do I need to safeguard myself? Whether I know anything and everything about the other person is something we may have to teach our young children. It's okay you get into romantic relationship or act upon romantic relationship, but at the same time you also need to know about the other person, and the other person also need to know about you. So that skill, I think, is something we may have to teach in our schools. So we need to educate our young children on these aspects. Not just sex education, but we also need to talk about sexuality. with young children.
I think if we postpone further, there will be a revolt. So before we face the rebellion, I think we should proceed to take care of ourselves. Yes.
One last thing I want to just say. General perception of mental health, we relate it with illness. The word mental itself, we relate with madness. But we need to understand mental health is not just illness. The trauma what we undergo in our day-to-day life, the stress what we undergo in our day-to-day life, all would amount for mental health. So in that sense, we have a lot of scope to work in terms of mental health, not only for us, for in the community, and more so with the victims of child sexual abuse.
So the lunch break is initially from 1:30 to 2:15. When do we reassemble? 2:15? 2:15? Half an hour is sufficient? We are not going to say that eat less. You can take your food without any hesitation. 2:15 we resume the session, and of course, as suggested by Brother Jamil, we'll continue with this presentation of the by the states. Thereafter, if we have time, we can have more discussion on this before we conclude the session. Thank you very much to all the experts here also for giving your time, physically coming here. I know it takes a lot of time to spend a few hours. You have to spend 10 times the hour, Thank you very much. We will assemble and meet again.
Thank you.
Thank you.
It's been a pleasure.
Yeah, wonderful. Yeah. See, I know if you have given online also, but then এইটো ৰাখি দিব তাত
Welcome back, ladies and gentlemen. Now we'll have the state presentation by the state representatives of Assam, Nagaland, Mizoram, and Arunachal Pradesh. The topic of the presentation will be 10 years of POCSO, revisiting commitments and priorities. Honorable Mr. Justice Lanusungkum Zamir, Member, Juvenile Justice Committee, Gauhati High Court, will chair this session. Honorable Mr. Justice N. Koteshwar Singh and Honorable Mr. Justice Ochinta Molla Buzar will act as the co-chairs. I request the members of the Gauhati High Court Registry to felicitate Honorable Mr. Justice Lanusungkum Zamir. First state presentation.
I'll proceed.
Yes, Lord.
Good afternoon. Welcome back again for the next session. 10 years of POSCO, revisiting commitments and priorities. Now the issue is, after the enactment of POCSO, there are some cases, there are some issues where cases are still not disposed of within the prescribed period. And the statistics shows that 96% of the pretenders are known to the victim child. Another aspect is that compensation is not paid in appropriate cases, particularly when there's a provision under Section 33(8) for paying compensation. So as we proceed with the program, I request all the presenters of the 4 states to touch on these issues also, especially the child-friendly court procedures, case investigation, and legal documentations are already there. But on the victim compensation also, I request that this issue should be also touched. Now, may I request the State of Assam to make its presentation.
Is anyone specifically prepared for this presentation? And if not, you can do it collectively.
Honorable Honorable Mr. Justice Jamir, Honorable Mr. Justice N.K. Singh, Honorable Justice Puja Barua sir, distinguished guests, friends from the other states, officers from the judiciary and from the police department, members from civil society organizations, and all those present here. First of all, as the host state, I'd like to welcome you to Gauhati, and I do hope that the arrangements made by us has been satisfactory and that you are enjoying your stay in Gauhati. I will now come on to the presentation on behalf of the state of Assam. Now, I could be a little biased because we have been given a particular template on which to base the presentation on. So I'll be a little biased when I point out the achievements made by Assam. So, I mean, please don't mind that. POCSO courts have been notified in all the districts by the Honorable Gauhati High Court. We have, from the Department of Women and Child, we have provided funds for setting up child-friendly environment and infrastructure in all the special courts of Assam. Till now, these are functional in Kamrup Metro, in Nagaland, and in Kamrup Rural. Some are under construction, and on some we are awaiting approval from the Juvenile Justice Committee to inaugurate them. To a very large extent, POCSO proceedings in Assam have become child-friendly. Then Assam has also set up, we have notified the special juvenile protection units in all the districts. In as many as 75 police stations till now, we have established the child-friendly corners. We have around 372 police stations in Assam, and very soon all 372 police stations will be covered. Now, reporting of cases under this act has increased due to the number of awareness programs that are being conducted by various organizations here. Capacity building initiatives, we heard a lot about this yesterday during the session on capacity building, and stakeholders like police, Women and Child Development Department, Education Department have carried out extensive awareness programs, which has perhaps resulted in a reporting of cases. Now, what was the situation in 2012? In 2012, when the Act was first enacted, cases were hardly reported. They were non-reporting of incidents under the POCSO Act. And there was lack of awareness about the types of crime under the POCSO Act. Most people did not know that it was a gender-neutral act. And at that point of time, most stakeholders were not even oriented and sensitized on the nature of crime, the punishment, the prosecutions, and the special provisions contained in the POCSO Act. Now, these are some of the actions which we have taken to address these challenges. My colleague from the police might like to highlight on the first 2 points.
Sir, if you could repeat that.
Yeah, I mean, on the first 2 points given in the slide, if you'd like to highlight on that.
If you are talking about the
Post of additional SP crime.
Right, sir. So, sir, as we are about the multitasking nature of the police, as I had mentioned yesterday also, which is taking away the kind of focus which is required to investigate such cases. So the Assam government has taken this initiative, and recently additional SP crime posts were created in many of the districts. In addition to that, there were posts created in CID Assam for SPs for looking into specific crimes. For example, we have a superintendent of police looking after crime against women and children, and then we have also an SP for cyber crime. Likewise, we have SPs for other crimes as well. So the objective here is to focus on a particular crime so that we have a dedicated team working on it. So this is the initiative taken. And about capacity building, it was discussed yesterday. CID along with BPRND, we are doing the capacity building programs on a war footing. It's like we conduct, apart from the capacity building programs taken up with BPRND, we are also conducting training programs at the range level as well as district level. Officers from CID travel to those places and conduct the capacity building programs. So this is it for now. Thank you.
Thank you, Gitanjali. The Government of India had issued a set of model guidelines under the POCSO Act, and these were adopted and notified by the state government, and these were circulated to all the district functionaries. We have support persons and support organizations under the various child welfare committees for victims of POCSO cases. As was pointed out rightly during one of the earlier sessions by Honorable Justice Koteswar Singh, that do we have these kind of lists at the district level? Do the DCPUs have these kind of lists? Yes, from the SCPS side, we maintain these lists at every district. And for especially for Kamrup Metro and Kamrup, Miguel is here. Miguel Das's organization, UTSA. In fact, they provide support persons in Kamrup Metro and Kamrup district. Then we have, Government of Assam has constituted the village and block level child protection committees in all the districts. However, I'd like to, clarify here itself that not all village level committees are functional, but we are trying our best because there are a large number of villages. So not all are functional, but yes, those close to the urban agglomerations are functional, doing their job. Assam perhaps is the first state where we are providing special relief to the victims from the JJ funds and even from our DCPU funds. This was one of the issues which was sought to be highlighted during this presentation. So we are providing funds to victims even from DCPU funds, apart from JJ funds. Then awareness generation, as I already stated, has been done in schools, in the children homes, and even at the community level. Now, in collaboration with the National Law University and the Judicial Academy, we have organized a number of training programs for judicial officers and especially for the newly recruited members and chairpersons of the child welfare committees and the social workers of the juvenile justice boards. NIPSID and SCPS, we ourselves are also conducting trainings for other stakeholders. As was pointed out yesterday, the Police Training College, Dergaon, is imparting training on POCSO to a large number of police officers at all ranks. CID Assam has also developed training materials on POCSO, and in collaboration with the Bureau of Police Research and Development and with resource persons from Health Department, Forensic Laboratory, etc., they are also not only developing training materials but are also imparting training. At the field level, we call them the 3 A's, the Anganwadi worker, the ASHA worker, and the ANMs, the auxiliary nurse midwife. So these 3 together, even at the ground level, we are trying to sensitize the public about the issue of sexual abuse and that these kind of cases need to be reported. Then contact numbers of our child welfare committees, JJBs, DCPO, and child welfare police officers are displayed at most prominent places in the districts. We also have complaint boxes in place at prominent places in like CCIs, DC office, even perhaps judicial offices. On this, may I request my colleague from the Judicial Department?
Good afternoon, everyone.
honorable judges on and off the dais, distinguished guests present in the House. I would like to highlight few aspects of the good practices that are carried out in the judicial system, as today is the subject matter of the same. So, good practices, we can say that when a child is brought to the court, the first challenge that is faced by the judicial officer during trial is that he should open up, he or she. It may include a child, a boy or a girl. So for that, we have the primary setup within the campus itself, where a child is brought and made to sit down with the support person, or if he or she is accompanied by the parents, then he is made to sit down in a comfortable way, and then he is brought to the, after some time when he feels comfortable, he is brought to the court with situation that he does not come in contact with the accused person. So that is one aspect. He or she is then made to sit down as a judge when we try the case inside our chamber, and the evidence is recorded in presence of either the support person that is appointed from CWC, or in presence of one of the person, maybe his legal guardian or anyone whom he has trust. So we are trying to create a child-friendly court, and I think that is everywhere in all the districts carried out in the same way in Assam. Then next we have the second thing is that when questions are put to the child, it is not put directly. So from the prosecution side, the judge has interaction with the child and his evidence is recorded. And then so far as questions by the advocate side is concerned, the advocates are made to give the questions to the judge, and then the judge is to put it. So we have come across, like, after the friendly atmosphere is created, so the child, they have opened up a lot. And we have seen that earlier, I can say that the number of cases that are reported, like in tuition classes, the abuse is going on, and in schools also, or along with the relatives, known persons. So many children have come up and have reported that this is a positive aspect after setting up of the child-friendly court. Then we have the support system, and also another good, we can say the good practices also include that the child or the victim, they are also given the assistance of legal aid counsel appointed through DLSA if required. So that the legal aid counsel used to assist them. What is the stage of the case, where it has proceeded, if interim compensation is granted in some cases. So the legal aid counsel, the support person, they used to tell the family members about the stages, the procedures that are followed during trial. Then also we have the compensation given when the child is first brought to the court. Suppose she is a pregnant victim. So in this case, during investigation stage itself, if she is brought to the court, she is noticed by the court and her requirements are noted down, and accordingly an interim compensation is directed to be given to the victim girl, and the same copy of order is sent to DLSA. So far as possible. So these are the good practices that are followed in Assam. Thank you.
Apart from what my learned colleague has stated, there are 7 vulnerable witness deposition centers in the 6 districts. These are the gaps and challenges, which we face on a regular basis. One is the non-sharing of information to higher authorities. Like something happens at the field, and I, as an officer of the Women and Child Development Department, I do not come to know about it. It doesn't get reported to me. This is something which is still a challenge for us. At times, it is seen that police and other authorities are not found to be sensitive towards these issues, either due to lack of knowledge or maybe deliberately. Then social stigma and taboo continues to be a challenge, particularly in Assam, in the tribal and minority-dominated areas, which a lot of people follow customary and religious laws. These result in child marriages, and POCSO cases, if any, mostly go unreported. Other areas where we have not seen much progress in the last 10 years are some which are already laid down in the JJ Act. Like we still do not have separate courtrooms with proper infrastructure like in-camera proceedings, separate entrance for the accused, separate entrance for the victim, separate waiting rooms. These are still a challenge in some of the districts. One issue which is regularly pointed out is the delay in filing the charge sheet. Some of the officers who deal with the victims are found to lack knowledge on child psychology, child-friendly language, behavior, and particularly lack of sensitivity on the issues. Now, due to social stigma amongst some communities, people are scared, they're afraid to report these kind of cases. Like we heard in the morning that a girl had eloped with her maternal uncle. In most cases, these kind of incidents go unreported. Long pendency in some cases is also a challenge because the POCSO Act provides timelines for disposal of cases. But I read in a paper yesterday that cases are still pending, even pending for 10 long years. These are some more areas which continue to be a challenge, particularly in Assam. We do not have trained experts. We do not have trained interpreters. And at times, support persons on the relevant subject is a problem area. Mental health experts to constitute the preliminary assessment board in all the districts is not available. It is still a challenge. Timely disposal of these cases and prompt release of sufficient victim compensation on time is an issue. Non-production of victims by the SJPU or the child welfare police officer before the CWCs within 24 hours is an issue. We need more public prosecutors. What happens is that we do have special public prosecutors, but in an instance, suppose a public prosecutor is absent on a particular day. What happens to the POCSO cases listed for that day? Can we have a concept of an additional public prosecutor, an additional one, in addition to what is already there in place? We need a standard operating procedure to be formulated for ensuring complete coordination amongst the various stakeholders involved in resolving or disposing of POCSO cases. What happens at times is the permanent address and the phone numbers of the witnesses are not collected. I mean, only their temporary addresses are collected. And once these people shift from that particular place, it becomes difficult even to trace the witnesses. Then in Assam, we just have 2 forensic laboratories, one from the government of Assam and one from the central government. But these are not enough. We need forensic laboratories, at least at the regional level, if not at the district level. This is very important for fast-tracking cases under POCSO. These are some of the statistics I'd like to present before you in respect of Assam from the year 2012 to October of 2022. Now, I won't read it out. These are the number of cases produced before CWC. This is 2366. Number of POCSO case victims who have received compensation from DLSA is 304. Number of victims who have been given shelter in CCIs is 433. Number of children receiving special relief as per orders of CWC and JJ Fund or otherwise is 57. Number of POCSO victims who have received assistance and support from support persons is 349. And number of POCSO victims who have received legal aid from our LPOs and the DLSs is 130. Now, on the way forward, I mean, at least after deliberating amongst ourselves on the issues, we feel that there should be joint and specific training for all stakeholders who are engaged in the justice delivery system for a synchronized and effective coordination in implementation of the provisions under the POCSO and related acts. We need to have more awareness about free legal aid services. In fact, people in the villages are hardly aware of this. We need to go down to the community level to bring about awareness about the free legal aid services. Special relief and victim compensation should be released on time. In-depth counseling is to be provided to the victim, the victim's family, and the community in order to help rehabilitate and reintegrate the victim into the society. Provisions of the POCSO Act should be introduced in school curricula in a comprehensible manner. The media should be sensitized on reporting these kind of cases. We still see that in most cases, the names of the victims are released. I mean, there are some guidelines on how the media should report it. So this media sensitization is extremely important. Engagement of special public prosecutor exclusively for POCSO court, and even an additional public prosecutor for the POCSO court. Priority should be accorded to speedy investigations. And coming to an end, these are some of the solutions to address the gaps. Speedy disposal of POCSO cases through fast-track investigation. Steps should be taken to expedite grant of compensation to the victims. Periodic sensitization, orientation on POCSO Act for all stakeholders, including police, doctors, and teachers. And we need to have the special infrastructures in all the special courts under POCSO. Coming on to some of the orders, this is an order which the government of Assam had issued on creating child-friendly environment in the special courts. Now, this is a notification by which we had adopted the central model guidelines. This is a view of the child-friendly court room in Nagaland district. This is the child-friendly room in the court, in the Gauhati court. This is in Tinsukia. This is in Kachar district. Child-friendly rooms in the courts. These are some glimpses into the training of the CWC members and JJBs conducted at the National Law University. Thank you.
Nagaland, please.
Respected honorable judges, respected dignitaries, senior officials, representatives from different departments, different states, ladies and gentlemen, a warm greeting from Nagaland. Today, on behalf of Department of Social Welfare, I take this privilege to present a very brief report on the implementation of POCSO in our state. So POCSO Act was notified and adopted in the year 2016. And once the Act was adopted, all the mandated machineries were put in place for speedy trial. Special court were instituted. There are at present 8 special court functional in 8 districts. One fast-track court is also set up in Dimapur district, and public prosecutor, additional public prosecutor, assistant public prosecutor have been designated as special prosecutors. At the same time, the Nagaland Victim Compensation Scheme 2012 is also notified in the year 2012, and under which from 2018 till date, 34 POCSO survivors have received victim compensation. Here, the District Legal Service Authority played a very important role. Legal aid councils are present in all the 11 districts, and free legal aid and victim compensation are all assisted by the DLSAs. Apart from the Legal Service Authority, we also have the Legal Cum Probation Officer under District Child Protection Unit, who also sometime, if need be, assist the special prosecutor during the time of trial, POCSO trial. Under, when we say compensation, under victim compensation scheme, as highlighted earlier, it's a very good scheme, but the process takes time. It takes months and sometimes even years to receive the compensation. So there is a special fund under Child Protection Services Scheme, as just like the Assam, we have a special fund for under the CPS scheme and Juvenile Justice Fund, where we provide interim relief for the immediate medical need of POCSO victim. Till date, 16 POCSO survivors have received this one. I remember there was one special case where, along with the child line, we ensure a safe delivery of a baby of a 14-year-old POCSO victim through this fund. So we also, like Assam, we also have this interim special fund, not just for POCSO, but for any child in distress. So, and this fund is not a fixed fund. As per the need of the child, this fund is provided from 5,000 to 50,000. We have even provided beyond 1 lakh also. So this is about the special fund that we have. And regarding this rehabilitation support, yes, yesterday we have emphasized a lot on institutional care being the last resort. But when it comes to POCSO cases, especially, I don't know about the other states, but when it comes to Nagaland, we have seen most of the CSA offenders are somebody from the family who lives very close to the family or with the family. So in such a situation, it becomes very important to extract the child temporarily and place the child in a safe shelter until the safety of the child is established. So at present, we have 58 registered child care institutions in the state, out of which 45 child care institutions are specifically for children in need of care and protection. Yes, we do not have any child care institution dealing exclusive on POCSO, but we have at least one children home for every CNCP. We have one children home in every district in Nagaland. So that's about the rehabilitation, the institutional care services that we have. Under Mission Vatsalya, we have 24 counselors engaged under the scheme, and NIHAMS was here earlier. NIHAMS have been training our counselors. From 2013, in the year 2013, 2 POCSO cases were registered, just 2 POCSO cases were registered. Now in 2021, there are 26 POCSO cases registered. So CSA cases have been gradually increasing, which also indicates the rising public awareness, rising awareness among the public and among the stakeholders as well. So when you say POCSO Act, I think I can safely say that Nagaland is a progressing state when it comes to POCSO. We are very slowly, but we are surely progressing. So this is about the present scenario. When it comes to gaps and challenges, there are lots of gaps and challenges, but I have just highlighted few. In fact, after all the session yesterday, we have realized that we have more gaps and challenges than we thought we previously had. Especially when it comes to support person. Yes, DCPU is maintaining the list of support person, experts, translator, interpreter, but I think we have to go back and redo our the list that we have as per the information that we got yesterday. So I have just highlighted 2 main points when it comes to gaps and challenges. One is issue pertaining to those cases that are reported, and the other one is those cases that are not reported. So those cases that are reported, the issue is slow disposal of POCSO cases. At present, we have around 52 POCSO pending cases in the state. So if you see the number and compare it with other states, it may seem like a small number, but when you do the ratio of the cases that we are receiving and the cases that we have disposed, the pendency rate is indeed a concern in our state. And it's not just the court. When you say pendency, we blame the court immediately, but it's not just the court, but the police, the medical, so many things are involved. For example, we don't have, Assam have said they have 2 forensic labs, which is very less. Nagaland has no forensic lab recognized by the court of law. We do not have any forensic lab. And whatever cases, POCSO cases that we receive are always a delayed report. So we have so many issues that leads to pendency of the POCSO case. So if something can be done in that line. Next is disposing of child sexual abuse cases through customary practices. Customary practices and customary law in Nagaland is very much prevalent, and I'm sure in tribal setup, I think it's still in other states also. Even in Assam, I saw in the PPT that this thing is very prevalent in Northeast area. So customary practices in Nagaland, so many issues are handled at the local level by the local bodies through customary laws. And it's not just about child sexual abuse, it's about any child issues, and including the women issues. Most of these issues are not, they are reported but not to the right authority. And these are settled at the local level. So this is one problem that we are facing. Reporting is done, but not to the right authority. So what can we do about it? So first is, as everybody has emphasized, continuous training, sensitization of all the stakeholders, be it police, medical, judiciary, support person, NGO, child protection functionaries. Continuous training, retraining, learning, unlearning, relearning, learning new things has to be done. And this, we have come to realize that a program like this have provided a very good platform to know each other. So maybe, as suggested by an honorable judge, we can go back and organize something like this at the state level, at the district level, when we go back. So this is one thing that we are going to take back home. Awareness generation at the grassroots level is very important to encourage not just reporting, but reporting to the right authority and reporting at the right time. So awareness generation at every level, it can be a very effective preventive measure. Under Mission Vatsalya, now village child protection, it was always there under CPS also. So the village, at the rural area, we have village child protection committees, and urban setup, we have ward level child protection committee. If these committees are strengthened, I guess most of our issues, or most of the issues that we were discussing right now will be solved. Yesterday we spoke a lot, discussed a lot, deliberated a lot on prevention. So how to reduce the risk. So some even suggested that POCSO should be added in a school curriculum. We don't have POCSO in our school curriculum, but we do have sex education in the form of adolescent education in the state school curriculum. It's from class 6 onwards. Since 2015, teachers are being trained in NIPSIT on POCSO. So these are some of the good practices. I would also like to highlight other good practices. We believe that one of the most important stakeholders of child rights are children themselves, and therefore to empower the children to claim their right, to empower the children to identify if somebody is abridging their right, or to identify if somebody is threatening their right. We have initiated several programs to help raise awareness and understanding of child rights among children. Some of these programs are, we had this 7 days mass awareness program. We went to schools, we went to Sunday schools, we went to summer camps, we went everywhere where children were there, and we did this mass awareness program. It was called Reducing Harm, and this Reducing Harm is based on this training manual. The training manual is called Reducing Harm. This training manual is developed by an NGO called ARS. It's Anya Rahid Zindagi. ARS is an NGO based in Goa, working very closely with victims of child sexual abuse. So this training manual is one of the best POCSO training manual that I have come across. It's not just for the caregiver, but it's also for adolescents, for children, the parents of the children, the teachers, shelter home. So it's a complete, very comprehensive, very interesting training manual. If you want, it's there online, or you can even contact the NGOs. This training manual go beyond good touch, bad touch. It talks about what is child sexual abuse, the process of abuse, the feeling associated with abuse, safety measures, assertive communication, how to say no. So this is a very good training manual. So we had this 7 days extensive campaign against this child sexual abuse using this training manual. This is one good practice that we have done in the past. And another one is empowering children. I Am Child Rights Ambassador program that we have rolled out. It is a platform upon which children are given opportunity to be the ambassadors of their own rights. Children from the schools are trained and they're empowered so that they can educate their peers in turn. No? We even gave them a badge. If you see in the screen, there's this round thing that says, I am Child Rights Ambassador. That's the badge. We even gave the badge to the children. But unfortunately, we have to hold this program because of the pandemic and school lockdown. But we are going to very soon, along with the education department, we are going to re-roll this program. And these are the glimpses of the school awareness that we carry out for empowering the children. As our member secretary, NALSA, Nagaland Legal Service Authority, highlighted yesterday, this is the child-friendly zone that is launched in Phek district, child-friendly court in Wokha. And that's the end of my presentation, but I have a small video, sir. If the house permit, I would like to play the video. It's just 5 minutes. It's okay? Okay. Before I play the video, I would just like to talk about this photograph. The photograph, can you show on the screen? Yes, this photograph, I took this photograph. It belongs to a 3-year-old child sexual abuse victim. When she was rescued and brought before CWC, she was holding this doll. This is her doll. So I took this photograph, and whenever I have to make a presentation on POCSO, I always end with this photograph. I feel this photograph says more. This picture says a lot, describe more than I can describe in words. So I'll just play the video. It's a very sensitive video. I'll just say something about the video first. This video is called Break the Silence. It's a testimony of a child who was sexually abused by her own father, a child who refused to remain silent. Her mother said, don't report, but she refused to remain silent and call up for help until one day the help arrived. So this video, we use this video to advocate on the importance of reporting, on the importance of speaking out. If abuse, to stop any kinds of violence, we have to speak out. So I'll just... It's in Nagamese, but it has subtitles. Thank you very much.
Madam, your video, the audio is not coming. So what we will do, we'll watch this video at the concluding part of the program. And now I request Mizoram to give his presentation.
Honorable Justices of the Gauhati High Court, members of Juvenile Justice Committee, senior officials, delegates and all invitees present here today, thank you for giving me the opportunity to represent my state, Mizoram, through this presentation. 10 years of POCSO, revisiting commitment and priorities in the state of Mizoram. The first slide shows the reporting of offense as per Section 19 of the POCSO Act. And from 2014 till this year, 2022, we have had a number of 1,000 cases in total that has been reported. And this graph also shows the district-wise classification as to the number of cases reported, with Aizawl being the highest, followed by Champhai, Kolosip, Mamit, and so on. The number of police stations and child-friendly corners in police stations, here also we can see the district-wise differentiation, and totally number of police stations in the state is 41, and out of 41 we have 30 child-friendly corners in the police stations, and out of the total police outpost of 11, we have 2 child-friendly corners in the police outposts. And these are some of the pictures of the child-friendly corners at the various police stations in the districts. And this picture shows the capacity building training that we have had with the police personnel in their own buildings. Reporting of offense as per subsection 5 and 6 of the Section 19 of POCSO Act, cases produced before the Child Welfare Committees. In 2012 and up to 2015, cases were reported as just POCSO. They were not, but from 2015, in the next slide, we can see that the case-wise reports have been coming in from 2015. And this graph also shows the POCSO cases produced before the Child Welfare Committees from April 2019 to October 2022. And this graph also shows the gender-wise POCSO cases produced before the Child Welfare Committee from April 2015 to October 2022. Rehabilitation of POCSO victims. All staff under the Child Protection Scheme are trained on POCSO Act. Capacity building is organized every year. Counseling of children who are not placed in children's home is being given. And for those children who are placed under non-institutional care program, sponsorship and foster care is being done. We also facilitate victim compensation claims. We refer them to the Child Guidance Center. And for those children placed in the children's home, counseling is given at the children's home, and we take care that their school education is not disrupted, and we facilitate victim compensation claims. And these are some of the pictures showing the capacity building trainings of the child protection staff. Number of children placed in children's homes due to POCSO cases. The first graph shows, the first table shows the data from April 2015 to October 2022. And the second table shows children in children's home due to POCSO cases as on November 2022. So as of today, we have catered to 45 children with POCSO cases. And coming to the medical examination, this is the table which shows the medical examination of a female child as per Section 27 of POCSO Act. Here again, we can see the year-wise distribution and the district-wise classification. And totally, the total is given at the bottom, and Aizawl district has the most cases with 295, followed by Lunglei, Serchhip, Champhai, and so on. And this table shows the medical examination of male children as per Section 27 of POCSO Act. Here again, we can see the year-wise distribution and the district-wise distribution. So totally, 720 number of children have been given medical examination. And these pictures show some of the training programs that we have had with the medical personnel within the health settings. Designation of special courts and fast-track courts as per Section 28 of the POCSO Act. Here we can see that only in 5 districts, in Aizawl, Lunglei, Siaha, and Kolosip, and Champhai, Court of the Special Judge, POCSO Act. In Lunglei and Champhai, they were designated in 2014, and in Siaha and Kolosip, they were designated in 2016, and the Court of Special Judge, Champhai, was designated in 2017, and the rest of the districts, 6 districts, Mamit, Serchhip, Longklai, Saitual, Khozol, and Nathial, have not designated till now. And designation of special courts and fast-track courts as per Section 28 of POCSO Act. Here also we can see that we have 2 in Aizawl and 1 in Champhai, which were designated last year. And these pictures show some pictures of the special court in Champhai, Kolosip, Siaha, and Lunglei. And status of cases in special court and fast-track court. So the number of cases, here we can see the district-wise distribution of the cases, where Aizawl has the most cases, and number of cases disposed also you can see in the table. And the last column is the number of cases pending for more than 1 year. So in Aizawl we have 40 cases, Champhai we have 14, Lunglei we have 6, Siaha we have 18, Kolosip we have 23, fast-track court in Aizawl we have 4, fast-track special court in Aizawl we have 21, and Champhai we have 4 pending cases. Special public prosecutors as per Section 32 of the POCSO Act. Here again we can see that Aizawl, Lunglei, Kolosip, Champhai, and Siaha have special court with the special public prosecutors. They were designated in 2018, 19, 21 respectively. And whereas in the other remaining 6 districts, we do not yet have the special courts, nor the fast-track courts. Victim compensation claims as per subsection 8 of Section 33. In 2015-16, we have utilized a total of 9,70,000. In 2016-17, we have utilized 24 lakh. 2017-18, we have totalized we have utilized a total of 1,22,25,000. 2018-19, 3 crore 1,70,000. 2019-20, 1,94,000, 94,90,000. Totally, we have utilized 6,52,55,000 towards victim compensation. Prevention of exposure of child with the accused as per section 36 of the POCSO Act. So here again we can see the district-wise distribution. Aizawl has a child-friendly waiting room as well as the single visibility mirror, whereas in Lunglei it is under renovation. In Kolasip we have the single visibility mirror, and Siahatu we have the single visibility mirror, and in Champai we have the child-friendly waiting room and the single visibility mirror, whereas in Mamit, Serchip, Longklai, Saitwal, Khozol and Nathial we do not have the special court. These are some of the pictures of the child-friendly waiting room in Champai, one-way mirror in Kolasip, one-way mirror in Champai, one-way mirror in Siaha, and evidence taken through video conferencing at Champai. Public awareness on the provision of POCSO Act as per section 43. So through television, print media and radios, we have done a number of public awareness, which has been done and is still ongoing. And we have developed a number of IEC materials in the local language, such as the POCSO Act 2012, translated into the Mizo language in 2014, booklet on prevention of child sexual abuse, translated in developed in 2015, guidelines under section 39 of POCSO Act, published by the Ministry of Women and Child Development and translated in 2015, video clip on the provisions of POCSO Act and personal safety education for children. These are some of the recent awareness programs that we had during this year in July and November 19, 2022. And these are some of the IEC materials that we had developed in the Mizo language. And these are some of the pictures of the awareness programs in the community by the DCPUs. Altogether, 420 times since 2019 till November 2022. 420 awareness programs have been done in all the districts. So these pictures shows the awareness programs undertaken in the districts. And interpreters, translators, and special educators as per section 38. So this table also shows the district-wise distribution, where totally we have 50 interpreters or language translators in the state, and we have 24 special educators, we have 2 sign language interpreters, and altogether 53 support persons. And this is a picture of the notification of the guidelines under section 39 of the POCSO Act 2012, which was published in the Mizoram Gazette on Tuesday, the 3rd March 2015. Some of our good practices is the Child Guidance Center, which is an innovative project set up by the Mizoram State Child Protection Society in 2015. We offer support services for POCSO victims, and some of our other services include psychological assessments and intervention, counseling, family therapy, bereavement and trauma services for victims, training of CCI staff on care and support of POCSO victims, and this center is operational with a multidisciplinary team of trained professionals such as psychiatrists, clinical psychologists, psychiatric social workers, physiotherapists, occupational therapists, speech therapists, sign language teachers, and art therapists. This is a picture of some of the activities that we are doing in the Child Guidance Center. And we have also appointed nodal teachers for child protection in 2,295 schools. And this is the picture of the notification designating the teachers to be the nodal officers for child protection officer. capacity building for nodal teachers. All the nodal teachers have also been trained. And another good practice is that we have trained all the 2,244 Anganwadi workers in the state on POCSO Act 2012 and JJ Act 2015 at the state and the district level. And another good practice that we had done is we had developed the MSCPS online monitoring portal. So from this portal, all the field functionaries, the field staff are able to report cases of sexual abuse, POCSO registration, everything is there, including their accounts and childline staff biodata. All that is being reported under this online monitoring portal. And the gaps and challenges that we are facing is unavailability of special courts in all the districts, lack of space, infrastructure for setting up of child-friendly waiting rooms and space for victims in some courts, which at times lead to exposure of the child with the accused. Insufficient human resources at all levels, separate medical examination and waiting room in some hospitals, unavailability of female doctors in some hospitals in the rural areas, lack of professional NGOs, consent sexual intimacy between two adolescents, as we have heard earlier, the Romeo and Juliet cases, and restoration of victims to families and homes. Our way forward, if we could have systematized monitoring and review committee at all levels, especially in the state and district levels, quarterly review meeting of all stakeholders regularly, strengthening and capacity building of counselors and other stakeholders for rehabilitation of POCSO victims, conducting more awareness program for the general public, strengthening of documentation, research, training of medical undergraduates and health care providers in child-friendly interviews and medical examination, and preparing aftercare plan for POCSO victim, follow-up of cases status of children, and accordingly prepare aftercare plan. Thank you so much.
Thank you, Mizoram. Now I call upon Arunachal Pradesh.
Good afternoon, everyone. Honorable Mr. Justice El Zamir on the chair, Honorable Mr. Justice N.K. Singh, Honorable Mr. Justice Barua on the dais, and all the honorable dignitaries of the dais. I am T. Pertin Louis. I am the Director of the Department of Women and Child Development, Government of Arunachal Pradesh. Before I proceed with my presentation, I'd like to take this opportunity to mention the names of my team who are participating for this 2-day state-level consultation, because I feel without their support, cooperation, convergence, and coordination, we will not be able to effectively implement the POCSO Act. So from the government side, leading our team, we have Shri C.N. Longfai sir, who is the Secretary, Women and Child Development. He is also the Secretary, Social Justice, Empowerment and Tribal Affairs, and also the Secretary, Home, Shri C.N. Longfai sir. Then we have Shri Jumtu Mingaji, who is the member of the State Commission for Protection of Child Rights, Arunachal Pradesh. We have Shri Obuk Panar, the Joint Director from the Department of Education. We have Dr. Tana Natum, who is the Nodal Officer, Child Health, Department of Health and Family Welfare. We have Sri Habung Gyati, who is the member of the Child Welfare Committee of Itanagar Capital Region. We have two additional SPs here with us, Sri Thutan Jamba, Additional SP Itanagar, and Sri Tasi Darang, Additional SP East Siang. We have Srimati Kago Asha Law, the Nodal Officer for implementation of the Mission Vatsalya scheme of the WCD department. We have Wihong Kim Hun, the District Child Protection Officer of Namsai District. And besides the government officers, we have also the judicial officers, Habung Sir, the Registrar of Gauhati High Court Itanagar Permanent Bench, who is also always a support system for us, for the department. We have Sri Yomga Adoji, who is the Member Secretary of the State Legal Services Authority. And we have also all the honorable judges of the designated special courts and the special public prosecutors. So this is the team Arunachal of Mission POCSO. Now I proceed on to the presentation. Although the progress has been slow, gradual, but we are consistently progressing, and these are some of the areas which we had done some progress. The awareness and victim compensation, we were able to do awareness programs, and because of the awareness programs, there had been an increase in the reporting cases of POCSO as well as claims for the victim compensation. And the POCSO courts has also been, or the special courts has also been set up. Then the subcommittee for the Vulnerable Witness Disposition Center has also been notified. Public prosecutors have been appointed. And the criminal laws has been also been amended by the state government. We were able to set up child-friendly police stations and also women police stations. And the interlinkage between POCSO Act 2012 and the JJ Act 2015 has also been strengthened. Coming to the first point, the state government has undertaken awareness and sensitization program on POCSO and on good touch and bad touch. Here I'd like to say that we had learned this, a new terminology of safe touch and unsafe touch and confusing touch. So from here on, we'll be using that terminology when we go for the awareness program. So we had been able to do awareness program at the district level, at the block level, and at the village level. And our targets were the educational institutes, both private as well as government schools, the panchayati institutions, the panchayat members, the NGOs, the community-based organizations, women organizations, the gamburas, which play a very vital role in the village level, and the general public. And in this endeavor, our state legal services also had been doing a lot of awareness program, as well as the Commission for the Protection of Child Rights. So this is a data on the awareness program that we had taken up by the WCD department. In total, we had been able to make 796 awareness programs. And we had done this awareness program in the schools. We had been able to reach to 88,693 school students. Then at the district level, various NGOs, gamburas, public, 4,012. At the block level, 6,548. And in the village level, 3,469. But much more is needed to be done. Now this is a data on the awareness program which has been conducted by the State Legal Services Authority. They had been able to conduct 1,175 awareness campaigns over the years, and they had been able to reach to 91,402 people. And one of the good practice what the SALSA had done in the state is that they had taken, done this awareness program on important national days and also on the local festivals. They had tried to reach to the people, create awareness on the festival days. And during the pandemic, they had this first Pan-India Awareness campaign and the second Pan-India Awareness campaign. Now, because of this increased awareness, the number of reporting of POCSO cases has also increased, and also the victim compensation has increased over the last 10 years. This is the data of the POCSO cases that has been shared by the police headquarters. Total FIRs 585, charge sheeted 511, the final report 46, pending 28, workout not arrested 90, and arrested 496. Then these are the details of the claims of the victim compensation as per the reports of the State Legal Services Authority. So far, 118 applications have been received, out of which 86 applications have been sanctioned, and 19 had either been rejected or returned. Then total amount sanctioned so far is 3 crores 68 lakhs 95,000. And these are the cases in the special courts. We have 8 designated courts in the state. So total cases, new cases registered, this is as on September 2022. So there are 17 new cases registered. Total cases disposed of is 9 and pending is 301. And the cases which are pending for more than 5 years is 23. And this morning, one news came in the print media and the social media that one accused was convicted in the special court of West Cumming district, Bombay. And these are some of our achievements, so to say. We have, as I had already stated, we have 8 special courts which have been designated by the state government for the speedy trial of cases, which are in Upia, Teju, Pomdila, Alo, Konsa, Zero, Pasighat, and Basel. And 9 special public prosecutors has also been appointed. For the Vulnerable Witness Deposition Center, a subcommittee has been constituted. The subcommittee had its meeting and it has recommended for establishment of 4 vulnerable witness deposition centers in the following courts located in these districts. That is Teju, Pasighat, Khonsa, and Namsai. And the initial allocation of fund for the same purpose has also been made by the state government for the current financial year 22-23. The state government has also amended the criminal laws and has also notified the criminal laws Arunachal Pradesh Amendment Act 2018, amending the IPC 1860, the Code of Criminal Procedure 1973, the Indian Evidence Act 1872, and the POCSO Act 2012 in its application to the state of Arunachal Pradesh by notification of dated 2nd April 2019. Now, as per this amendment, the section 376AA of IPC inserted by the criminal laws Arunachal Pradesh Amendment Act 2018 states that whoever commits rape on a child up to 12 years of age shall be punished with death or rigorous imprisonment for a term which shall not be less than 14 years, but which may extend to imprison for life, which shall mean imprisonment for the remainder of that person's natural life, and shall also be liable to fine. And in case of gang rape, as per section 376D of IPC, inserted by the criminal laws Arunachal Pradesh Amendment Act 2018, punishment for a gang rape on a child up to 12 years of age shall be punished with death or rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to imprisonment for a life, which shall mean imprisonment for the remainder of that person's natural life and shall also be liable to fine. Now, these are some of the good things that has been done. We have total 109 police stations in the state, out of which we have 7 functional women police stations. And in the remaining 102 police stations, we have women help desk, which is being manned by the lady police personnel. And we also have child-friendly police stations, which has been set up in Alo in West Siang district, Pasighat, East Siang district, in Zero, Teju, and Seppa. And this will be continued and extended to the other police stations also. So this is just a glimpse of those child-friendly police stations, a few photographs of East Siang, Lower Subansiri, Lohe. Now, next, we have also strengthened the interlinkage between POCSO, and so all the child welfare committees and juvenile justice boards in all the districts has been constituted, with an additional in the capital region. And we have also set up all the district child protection units. The police headquarters has also designated special juvenile police units in all the districts, and they have designated child welfare police officers in all the police stations. We have 15 child care institutions which has been registered under the JJ Act, and the village level and the block level child protection committee has also been constituted. Now, of course, there are many gaps and challenges. The first is lack of special courts and special public prosecutors in every district, and also child-friendly infrastructure. Then we have shortage of women police stations and women police personnel, lack of female doctors to examine the POCSO victims. One of the main problems that we face is lack of motorable road connectivity because of the tough geographical terrain, rugged terrain. This causes a challenge in carrying out awareness activities and also causes delay in timely reporting of cases. There is lack of awareness on victim compensation scheme. A lot more awareness work is to be carried out. And there are parents who are still reluctant to report cases and claim compensation for their children or their wards due to fear of the social stigma. And so more work is to be done on this. Non-availability of independent chairperson, secretary and other officials and staff at District Legal Services Authority. Then the procedure of availing the benefits of victim compensation is also very lengthy and cumbersome. And more sensitization and capacity building of police personnel, health functionaries and other stakeholders is necessary while dealing with the POCSO victims. And the way forward is that we need to set up special courts for every district with a child-friendly infrastructure. We need to appoint special public prosecutors for every district. Victim compensation is to be given in a time-bound manner, and simplifying the procedure for availing victim compensation. Victim compensation fund is to be placed at the disposal of State Legal Services Authority for enabling timely payment of the compensation, and also some funds at the disposal of District Legal Services Authority for payment of interim compensation. And as I already stated, more awareness drives is required to be undertaken for POCSO Act and victim compensation scheme. And proper counseling is also much needed to be given to the parents and victims to claim for their rights and entitlements. Then sensitization is one issue. This is to be given for all the stakeholders, including health officials, panel lawyers, paralegal volunteers, magistrates, police, need to be conducted from time to time, especially sensitizing all the health staff to ensure appropriate and dignified behavior with child victim, and also creation of more health facilities to ensure coverage of every POCSO victim and more female doctors needs to be appointed. These are a few pictures of the awareness campaigns that have been organized by the district child protection units of the WCD department that have undertaken various awareness programs on the POCSO Act in various districts of the state, in various and reach to various categories of people like the students, the Gamburas, the public, the women organizations, the CBOs. So these are a few pictures of the awareness programs that were undertaken. And our State Commission for Protection of Child Rights, they have also undertaken training program and imparted training program to the newly appointed sub-inspectors of police on JJ Act and also on POCSO Act. They also imparted training to the newly appointed administrative officers and also had imparted training to all the police officers. This is one area where our Child Rights Commission is also taking serious action. And the Child Rights is also using the electronic media, radio talks to impart awareness on POCSO Act and the Victim Compensation Act. This is a notification of the appointment of the special public prosecutors. Then this is the notification of designating the special courts. This is the notification of the block level and village level child protection committees. So with this, I end my presentation. Thank you very much.
Thank you, Arunachal Pradesh, for the wonderful presentation. Deliberations will start after having tea break. But before the tea break, we are informed that the video that Nagaland wanted to present, the defect is solved. So let us have a look at the video.
My 16 years as I'm with us for this. Mahala family the pastor as by doing family one pula she power physician. So many when to mom going across the nation. With the still telling us hello, could be 3 years later. Din the biology ahead, but calling ahead, correcting it ahead, the from Korea, I come stay in a current, I'm not going to get the coming again, like if I never had the glow, I will tell you. You can't be, you can't share with the bomb back and do share. I'm not going to share, I'm not going to be a compliment share. So, I'm not going to say, child, I'm not going to say, I'm going to say, child, mở từ cái phút của là tại từ sáng đến giờ ở năm quán này tôi nói anh chỉ được anh chỉ nói chuyện này teachers communication, miscommunication, tahan lagi nutun jangan berthai je, have je, bapa kita jadi jasa. मुझे अगर आने लॉट चाहिए तो मैं पहले खोल भी जाने खोल कोई ग्राफिक्स भी सामने तो देखो ताहल आने मुझे हमको जिंदगी मुझे खुशी खुशी पैसे बनाना आराम से जो मुझे हल्की तो लगो मुझे खुशी खुशी बात से खोले या कि मैं सब कुछ मुझे First time I had really खुशी खाना really मेरा आम का खुशी पैसे मतलब तीन पहले से मैंने के हम पूरा और इसे मैंने आगे जाने का पूरा मेरा कुछ मुझे स्कूल भी जाए बस फैमिली दूसरी ऐसे मैंने बस करने के लिए ऐसे मुझे मुझे क्लास थाने से मुझे diploma presentation ko, talagang nagtutulong mo siya ko. Kasi yung mga nilisa, ito ko rin ka naman, stage kami na dyan na ko naman. And just we have on high, sweetly singing all the times, and the world can hear cry, we go get the joys back.
We'll assemble back in 10 minutes.
Look, hela
係劉將近拎路啊，佢啦將近拎路啊，係啦劉將哦，我近 just hold 個出息啦。
没讲话吧，你说你。
没讲话这个咯，没讲话这个咯。
Shift this. Oh, sira, aika paljon. Oh, sira, ketika ngapa sira kan? Nikmat dan ulu kan tahan.
I think it's better to say good evening now, because perhaps, but I will not say good night, because that would wind up the session.
Welcome back, ladies and gentlemen. After very informative panel discussions and state presentations, we have now arrived at the closing session of the state-level consultation on implementation of the POCSO Act 2012. Honorable Mr. Justice N. Koteshwar Singh, Chairperson, Juvenile Justice Committee, Gauhati High Court, will chair the closing session and present the key takeaways.
Good evening. Yes, this session is going to be the most challenging session. First of all, the kind of issues we have discussed. How do we deal with those in our respective jurisdiction? And also, the immediate challenge is to keep the attention of the participants alive. The program says 4:15 is the end of the program, but we are beginning the last session. And everybody is looking at their watch, obviously. So we will not take much time. We will take your indulgence. We will extract some promise from you that you will be here for at least 15 minutes so that we can wind up properly, because everything has such a beautiful beginning, must be ended beautifully. We can't be abruptly ending the show. Before we open up the session, I just wanted to share a few thoughts, especially being a judge, I am more biased towards the judges and lawyers. As I was thinking, listening to this entire proceeding, see, one thing's come out is that yes, we are dealing with a criminal proceeding in a special court, special enactment called POCSO, where again, as a judge, we will be required to decide whether one is say, guilty or not. The prosecutors also would like to see whether they are to end in a conviction. So is the investigators, but not necessarily others. The interest, their difference. The interest of other stakeholders is not necessarily to prosecute or convict the there is to assist the system. Now, but ultimately what we see is that the interest of the child, best interest of the child is again coming again and again in a proceeding. Therefore, through backdoor means, we are bringing the principles of JJB in POCSO proceedings also. And if you see Section 3 of the JJB Act, which lays down the principles which will guide the proceeding in a JJB, I feel that though it is not specifically mentioned in the POCSO Act, these must be also the guiding principles. Because our focus is on the child victim. We have all kind of crimes taking place. We have rape cases, dowry debt, drug addiction, corruption, murder, dacoities, all kind of things. But why we don't spend so much time? Why we are spending so much time in POCSO? It is because the child involved, the child victim. Therefore, our focus, in my view, will be on that. Yes, the accused, rights of the accused are also important. There is no doubt about it. A huge jurisprudence has evolved how to protect the rights of the accused. But in victimology and specifically the victim, the child victim, JJB Act has been there. Those who come in conflict with law and those who are in need of also care and protection. But in POCSO, we see we are focusing on the child. Therefore, in my humble opinion, yes, the best interest of the child must be kept in mind by everybody, even the courts also. To that extent, sometimes the court may have to be proactive. They may not take the role of investigators to find loopholes and trying to bring new facts, but there is a very important section under the Evidence Act, Section 165 of the Evidence Act, which enables the judge, it authorizes the judge to ask and put questions. The judge may, Section 165, for those who are not familiar with the day-to-day statutory provisions, I'll just read out Section 165 of the Evidence Act, which says, the judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases, in any form, at any time, of any witness, of the parties, about the fact relevant or irrelevant. Relevant or irrelevant. Lawyers are not asked to, cannot normally ask questions, argue on irrelevant fact, but judge can also ask on irrelevant fact if ultimate purpose is to find out the truth. Relevant or irrelevant, and may order the production of any document. Very important. We can ask the prosecutor, we can ask any authority, why can't he produce? Or thing, material exhibit. And neither the parties nor their agents shall be entitled to make any objection to any such question or order, nor without the leave of the court to cross-examine any witness upon any answer given in reply for any such question. Of course, I will not go into the other provisions. What I am trying to emphasize upon is that you have a powerful tool to intervene on the strength of Section 165 Evidence Act, especially in reference to the proceedings under POCSO. You may say then, okay, I may ask question, but then can I ask a question to a person, anybody? Yes, again, Section 311 of the CRPC. I just read out also for the benefit of others also who are assembled here, those who are not necessarily lawyers or judges. 311 CRPC again says, power to summon material witnesses, examine person present. Any court may, at any stage of any inquiry, of course this inquiry does not mean the investigative stage, that is settled, at any stage of any inquiry, trial or other proceeding under this code is still applicable. POCSO Act says, wherever which is not to the contrary, the provisions of code will apply. That's why there is no doubt about it. Summon any person as a witness. Suppose what has happened is that sometimes the investigation, either due to genuine lapse or mistake or deliberate do not call upon an important witness, which you think the court thinks is very important. If he or she is examined, perhaps the critical question which is baffling the court may be clarified. Why not use this section 311? Or recall someone not summoned as a witness, or recall and re-examine any person already examined, and the court shall summon and examine or recall and re-examine such person if his evidence appears to be essential to the just decision of the case. But then, because of the habit, because of the way our judicial system functions, many of the judges may not be willing to invoke these powerful tools of law. At least I can assure you from my side that if you invoke these provisions of law for a just decision, do not be afraid of any, hierarchy in the hierarchy. If you have done your job properly, for the reasons, good and sound reasons, I don't think you will have any reason to be apprehensive of any adverse action. But these I just wanted to share, these are very important tools, especially for judges, because what I have seen is that, the court cannot remain a mute spectator to what is happening, unfolding, either because of some deliberate or mistaken or genuine bona fide reasons. Certain important facts, evidence have not come to the light, which can be easily brought according to the judge, according to the court. Certainly, you can invoke these powerful tools, the statistic tools available with you. I do not wish to take much time. Already we have taken time. My brother wanted to share a few thoughts. Before that, then we can have some more discussion. Then we can wind up, because I understand not much time is there. 5-10 minutes. Then we can wind up. Thank you.
Good evening, everybody. What I want to refer is Section 19 of the POCSO Act. Why I am referring, this Act enables any person to also give information of a likely happening that may happen. And if you notice Section 19, they will have to report either to the police station or to the special police unit, special juvenile police unit. So this means if a person either sees an event going on or a likely event to happen, will have to go to the police station, which may be a little away. Once he goes to the police station, the police will consider it to be information in the regular manner, that is 154 and 161. And maybe the person will require to give a statement. In a situation where the person possibly doesn't know the possible victim, or he also doesn't know the identity of the possible perpetrator. So in this circumstance, I feel if we can have some kind of a WhatsApp number or a phone number which will be given wide publicity, and the police stations will be backed by something like a mobile squad or something who can immediately react, even the identity of the person giving the information may not be disclosed also. If the police receives this information, I think under Section 19, they can immediately start acting. If some mobile squad or something is available, they can easily, within a very short time, reach the place where from the report is made. And from themselves, they can find out. If actually some act is going on, the police can act on it. Because otherwise, the informant, suppose somebody notices something, he may be a little reluctant to go to a distant police station to actually make a formal report. This is possibly, it's already prevailing in the Gauhati city buses. You always notice one big WhatsApp number. Any complaint you want to make, there's it. So this thing can easily be put into place. And it will, and this can be easily saved because normally police cannot act without there being a FIR. FIR is the initiation, that is Section 154. But exceptions are there in the Wildlife Protection Act or in the NDPS Act, etc., where police also act before the actual FIR is lodged. And maybe Section 19 is also of the same nature. And this, the authorities can think about it. And then if the reporting is more, the prevention will be more. And secondly, if there is a possibility of an anonymous report being made by anybody, maybe the perpetrator will think twice before committing an offense also, because he may be knowing that I may be watched by anybody and it can be informed, and there is a likelihood of the police, etc., coming to the place. And second one, I wanted just pointed out that thought occurred to me during the course of these 2 days regarding the long-term effect on the victim, especially the mental aspect. When the courts are actually conducting the trial, they also, the judicial officers also happen to come in a close contact with the victim. And if you feel in your mind that there is some long-term effect, maybe the victim concerned can be referred for appropriate medical aid, medical treatment for that purpose. Thank you. Yes, in fact,
what Brother Chintu is saying is absolutely correct. See, the POCSO courts are very powerful. See, don't wait that unless somebody makes an application, because you are equally responsible for the welfare of the child. See, the best interest of the child. If you think that there's something amiss, why don't you take it up as a miscellaneous application or so? You can make a proceeding and pass appropriate orders. Nothing prevents you to pass any such order so long as it's within the parameters of the law and as well as for the welfare of the child. Because, see, unless it is barred by law, I don't think that any such provision is there that you cannot do this, you cannot do that. Wherever is there, then of course that you can't do beyond that. But wherever is possible, you can be a little bit proactive rather than merely a kind of neutral arbiter which you are trained to be. In any proceeding, even criminal proceeding, we don't interfere much. We don't intervene. It's for the prosecution to prove their case, defense to defend themselves, then we decide a case. But in a POCSO case, the judges have to play a little bit more proactive role. Even if you feel that if a child victim who has been produced giving testimony is not properly taken care of, why can't you write orders, refer to the CWC, seek a report from that. You are in session, you are holding it, you can seek a report. Yes, what has happened? I see the child is not comfortable or not taken care of. Seek a report. Nothing prevents it. So these are some areas, these are all of course green areas, virgin areas of many law, but please do not hesitate if you think that is proper, necessary to venture into it. I don't think one should be apprehensive unduly what the High Court will say, because you will not have so much of precedence. POCSO 2012, how many cases have been decided by the High Courts or Supreme Court, except maybe this determination, age determination. No, that's a typical case which we see. Otherwise, very few cases which is coming reported. So make your orders without any hesitation.
Regarding the High Court may take action, recently I had a complaint from one bar that a particular judge was not allowing the evidence to be taken and he was putting question on himself. This is what Justice Singh had referred to, Section 165. So that officer was adequately given the protection. But the objection of the bar was that he's not allowing the lawyers to put the question, and the court himself is putting the question. So this is...
No, these are very delicate areas. Obviously, Honorable Chief Justice of India has recently remarked also that the lower court judges are not passing bail, everything, all are coming to the High Court, Supreme Court. Why the same facts? If the High Court can pass bail order, why not the lower court also? The same materials were there. But then lower court judges are reluctant because they feel that somebody will file a complaint against him. Oh, he has so-and-so, he has done this. Oh, so file complaint. Why should I take the responsibility? But then you have to be also, you are a judge. Why should you be afraid of this? You know, that's what when you became a judge, you took a note without fear or favor. Neither fear nor favor. Then why you are fearing now? So, I mean, these are, of course, they are not meant to be discussed openly with non-judicial officers. But then we are discussing POCSO. Other stakeholders also have a right to know what is happening in judicial system. Transparency, see. So, I would urge upon POCSO judges don't be, apprehensive of what the High Court will do, what the High Court, my portfolio judge will say. You do your duty, with conscience, nobody is going to touch you. But anyway, having said that, we have heard from Mizoram, Assam. We haven't really heard from Arunachal and Nagaland. Can we have some feedback, comments from your state, or what we can do? Because what we are thinking is that, see, though a lot of progress has been made in all these states, as mentioned by every speaker, there are some areas where we need to work upon. And as a Juvenile Justice Committee, we'll be very happy to work with you to plug those loopholes or make up those deficiencies wherever we can. Therefore, please do not feel shy. If you have anything, of course, we have heard. But if you anything additional you want to have, you can certainly, before we'll all say bye-bye to each other.
Sir, may I?
Yes. Yes.
You're
from Mizoram again.
Yes.
You're Mizoram. We are offered to Arunachal and Nagaland. Then, unless you have shifted your Arunachal and Nagaland. Yes, Arunachal.
I'm having a sore throat, so my voice may not be that audible. In my short term of service, I have noticed in Arunachal Pradesh that when, as a judges, we receive cases after charge sheet, but definitely when the case is registered, the FIR reaches us. But substantial part is done by the investigating agency, and we see the responsibility of the Child Welfare Committee. I would say that it's not complaining, but shortcomings which I have noticed in the investigation is that there is a mandate that the age of the child has to be determined in terms of the documentation of a first school or other matriculation certificate. But in investigation throughout, I've seen that they will simply get a birth certificate, and they will just, based on the birth certificate, they'll try to say that this is how the age has to be determined. Obviously, those initial things are not done. And secondly, the medical officers who examine the victim are not following the guidelines, model guidelines which we spoke about, which was issued in the year 2014 by the Ministry of Health. So I was in the state of Mizoram and Assam. I think these guidelines have been adopted. So these guidelines are required to be adopted by the state of Arunachal Pradesh so far as examination of victim is concerned, how the format is to be followed. Secondly, the Home Ministry, because we are very fortunate to have the Secretary Home also with us, who is also the Secretary for the Social Welfare Department. The Commissioner Home has to issue an order saying that the investigating agency has to abide by the rules of JJB in order to determine the age of the victim. That is not done. The medical officers will have to stop testing the two-finger test, and it has to stop. The guidelines have to be adopted. Director Madam is also with us. In Arunachal Pradesh, I have seen the child welfare committees are not functional. Maybe there may be many challenges, but has there been any even once that the members of the child welfare committee has been trained? We have one of my friend who is a lawyer, practicing lawyer, and he is a member of child welfare committee of Papupare district. I'm not asking any specific question to them, but I think there has not been a proper training of members of the child welfare committee. If we expect some services from the police department, health department, child welfare committee, and they have to be aware about this. So even the concerned minister who came from Arunachal Pradesh, he admitted that there is a lack of awareness. So my request would be that...
Yes, so the secretary also here, we are very happy that he himself is also here. So he has heard you directly. Here, not hearsay evidence, direct evidence. So I'm sure you'll take care. Of course, the whole, I'm so happy that you have come. The director has come also, the secretary, then director, Women and Child Development, Social Justice. All are, so well represented. I'm sure the government will take it with right earnest to deal with these issues, what has been done in other states. So I'm sure we'll see much more improvement in Arunachal Pradesh. Any from Nagaland? Anything you'd like to say? Share.
Hello.
Yes.
Respected Chairman, Honorable Mr. Justice Koteshwar Singh, Honorable Judges of the High Court, dignitaries on and off the dais. It is my absolute honor to be part of this great event among all the distinguished members present here. I would like to share some collective points of takeaways from this 2-day state-level consultative program. Firstly, I would like to share that we have realized that the role of the support person is really important for giving assistance to the victim of POCSO. So, as far as the CWC is concerned, we do entrust the child line or the DCPU or for that matter, even like the social worker of the CCI to accompany the child victim during the initial stages of from filing of the FIR, medical examination, trial procedure. But we do not officially assign one particular person to accompany the child or the family from the start till the end. So that is something we really need to put into practice. And as we go back, we will surely practice that. And we feel the need to come up with SOP for the support person so that there will be better coordination and cooperation of the support person in a state with the various stakeholders. The next point is that lately we have come across a lot of teenage pregnancy or what is called the romantic cases. So we realize that there is more, we need to do more sensitization, especially amongst the children in the school level as a preventive measure. As rightly pointed out by one of the resource persons, prevention is always better than the intervention after the harm has happened. The Department of School Education will also take the responsibility for sensitization programs for all the schools head of POCSO, on POCSO Act, which will be conducted in all the 16 districts in association with the Department of Social Welfare and the DLSA. They will also make sure that the class-wise lesson topics will be prepared on important aspects of the POCSO Act and taught to the children under the co-curricular activities from the academic session 2023. And efforts will also be included. Efforts will also be made to include the lessons in the formal curricular as well. The Health Department will also coordinate with all the stakeholders and work on a child protection policy with clear roles and guidelines to be followed by the hospitals as and when they receive POCSO cases.
Yes, in fact, thank you very much, Madam Program Manager. Yes, in fact, that is what we also all agree, because this is a legal, this justice delivery system where not only the investigators, the police or the judges, they play important, but equally these support persons at every stage, right from the stage of filing of complaint, investigation, during the trial also. So it is very important that we have to involve these support persons of various categories in every stage of the proceeding, right from the initial lodging of complaint till the end. This is something very important what you have mentioned also. Yes, thank you very much. Sorry, I didn't want to discourage you, Mr. from Mizoram. I don't want you to go, disheartened. I could not speak. Please, what do you want to say?
I forgot what I wanted to say, but what I did not forgot was that the takeaway.
Yes, please.
Since I'm the chairman of the commission, I think all stakeholders, all the duty bearers I need to get them together to have a concerted effort, intersectoral collaboration, mainstreaming, convergence for monitoring, and ensure better implementation of this POCSO, so that I'll get back and I'll gather them.
Absolutely. In fact, that is what in the beginning also, when the process, this consultation process was conceived of and was in progress, as we come to a conclusion, I mean, this is something that cohesive, cooperative, functioning of all the stakeholders, that is the key to the success of the proper implementation of the Act. So I'm very happy everybody came to Gauhati with a lot of expectation, and I'm happy that everybody is going back smiling. That is, I think, it indicates that it has been a grand success. And yes, as a committee, we are always willing. Please do not hesitate. In fact, Nagaland also, you mentioned about going back and trying to reach out. Arunachal Pradesh has done wonderful. Mentioned by Madam Director also how they use legal service authorities to reach out to schools, colleges, and public, even during these festivities. Christmas is a great time also. You don't have to go to church when they come out, celebrate Christmas here and there. Yes, have something, I mean, you don't have to preach in the church. I mean, don't keep it. But then there may be occasions, there may be celebration here and there, gatherings. No, in fact, Hornbill Festival. I mean, I think you should take advantage of it. I know I think there's a stall also, but not merely stall like selling, brochures or like cup of tea, but selling ideas, go out more. So I would request, brother is here, he himself is a child, he will know better how to reach out. So these are good opportunities when people are assembled, drive home this, because it's difficult to get audience. My experience is if you say, okay, organize this awareness program, these people go and somehow they manage 1 or 2%, but nobody has time. But when people are assembling voluntarily, that's the greatest opportunity to spread awareness. So thank you very much, everybody present here. Yes?
If I may have a moment, please.
Yes.
This is in response to the Honorable Justice Borwa.
Yes.
As Sir was mentioning about whether there is a system in place where such cases can be reported through a number. We have 181 Sakhi, which is maintained by the Social Welfare Department, in addition to 1098 Child Line. And these two numbers will be integrated.
No, we are aware of it, but it's not having appropriate publicity so that common people on the road also knows about it.
Right, sir. And for that to happen...
in fact, and the publicity will carry the message more regarding this is what actually was intended.
And it will be made into one number, 112, so that everybody remembers.
At least what I referred, city buses, is very prominent. Behind every bus, that huge number is given there.
Right, sir.
And if anybody notices any traffic violation of a bus, he can immediately inform the authorities then and there. So we want to also bring it to the same state.
Right. One more
exactly,
thing,
that
sir,
is what was meant.
Right, sir. About the anonymous reporting, if you were mentioning, sir. Yes, there is a website which has been launched by the MHA, cybercrime.gov.in, wherein a citizen can report anonymously. This is mostly for the cybercrime cases, but as we know, POCSO Act cases are also taking place through the cyber.
No, exactly what was meant was immediate action.
Right.
Suppose somebody on the road going notices something, he can pick up his phone, make a call, and response will be immediate, so that when the act is actually going on or about to happen, somebody reaches that spot. This is what actually I intended.
Right.
As we wind up, I am reminded of my brother Justice Ali. In the beginning also he mentioned that when we go back, so what is the takeaway? I mean, what do we do? When we go back, our knowledge also will slowly evaporate. Before it evaporates, I would request everyone to note down, at least in your mobile phone, whatever is comfortable. And you be resource person in your respective states and districts. Because see, it's not that everybody is able to come here. Only few of the fortunate of us, like you are here, sharing this wonderful platform, ideas. Why can't we go back when you go back to Arunachal Pradesh, Mizoram, Nagaland, Assam also, in our respective districts, we share this, what we have learned. it'll go down well. It is also one of the ways to enhance the capacity, this mechanism capacity building. Because we are the holder of this knowledge. At least 2 days, wonderful session we had. We had some ideas, certainly. If not entire idea could not be grasped, but in certain important areas has entered our mind, it is on our concept. So it can be clarified. Kindly carry forward, be resource person in awareness programs wherever any district. I request legal service authorities of all the states to continue this program, and you can be a very good, wonderful resource persons. That's why we can carry forward. This is a challenge, an ongoing challenge. There is no short-term solution, neither is there instant solution. There is no, Ceridan for headache. It's nothing like this. It's an ongoing process. There will be new challenges also in the process, but we'll able to resolve and meet these challenges in a much more effective manner. Thank you very much for my brothers here who have taken all the time to be here since yesterday, and all the wonderful participants and the director, the secretaries are here also, Assam, the Arunachal, and from Mizoram also they have come, Nagaland, come all the way from there. I'm very grateful to you that you could, and also that the hospitality extended by the government of Assam and UNICEF. I'm very indeed grateful to both the agencies who have been, without their help, it would have been possible to have this wonderful session. And of course, the most wonderful is you who have listened to us with and absorb whatever we've been shared in this through virtual as well as physical mode, and kindly carry forward your knowledge, share with others. Thank you very much. Good night.